Item for delivery of order, item number 31, FAO 65 of 2024.
Partly allowed.
Obliged.
Obliged.
Yes.
I'd like to pray for allowing me to move a unlisted release matter.
When?
This is if possible today. This
Today-
is the FAO tomorrow being the last day. At 2 we have filed an FAO
No, as last item we will try.
today. I'm not.
Yes.
May I put before Lordship? I put before Lordship for listing a FAO tomorrow. There are some
Tomorrow not
urgency-
possible, already lot of cases have been
My lord, here is urgency.
in vacation bench.
Must.
Vacation bench. Yes.
May I please, my lord, I pray for listing upon IA. I have filed for stay, my lord. What happened in this case, my lord? There is no stay and REIT is issued, my lord. For tomorrow, my lord. REIT is already issued, my lord. That's why I'm
No.
saying.
Yes, sir.
When the next date is fixed.
My lord, REIT is issued, although next date is fixed on 29/7 for report, my lord. REIT is already issued, my lord.
Maybe
So in the meantime, my lord, decree may be
No.
executed, my lord.
after vacation.
My lord, if the decree will be executed, then my lord, this appeal will be.
After vacation.
At least, my lord, on the 30th, my lord, vacation.
No,
court,
no.
my lord.
Vacation bench.
Petition bench. Order, one.
Let's say. Let's say.
30th and 10th. It's very good.
We'll say. If we can place it before the vacation bench.
My lord, I will submit the mention, my lord.
Pardon?
I will submit the mention, my lord.
Yes.
Already.
Lordship, I pray for listing of an urgent FAO for today because Lordship, the
Today not possible.
then
You see,
Lordship,
today 30 matters are listed for hearing.
Lordship, the urgency is that the opposite side
Maybe.
is already starting construction after rejection of our injunction.
No.
They've already collected building materials.
No,
Lordship,
before
may I-
vacation bench.
Lordship, if not today,
Sorry.
tomorrow, Lordship,
Yes.
I request.
May I please, Lordship, my lord, I need to mention for listing, my lord, one CRP for motion, my lord, tomorrow, my lord. Matter
not possible.
fixed on 16/7, my
Maybe,
lord.
maybe.
My lord, then vacation court, my lord, because matter is.
Vacation court, yes.
My lord, another prayer, my lord, regarding item number 25. My lord, with the consent of the other side, my lord, let okay, matter be listed on after vacation, my lord.
25.
25, my lord.
Mr.
T-shake, my lord.
T-Shake.
T-shake,
T-Shake, learned counsel for the respondent number 6 and 7.
my lord.
With consent from the other side, first for listing the matter after vacation. Fair allowed. Recess shall list the matter immediately after reopening of the vacation.
I know that.
Yes.
I'd like to mention for listing of a civil revision on vacation bench manager.
On?
Vacation bench
Okay.
on 30.
May it please, my lord. My lord, I beg for listing of an interlocutory application, my lord, on the day, reopening day, my lord.
Okay.
14th. Deeply.
CRPIO on vacation bench.
Okay.
And yet another minute for admission that also. No.
May it please your lordship, with due consent from other side, I beg to mention item number 29 of today's list, your lordship. Counsel representing the case has some difficulty, your
Court
lordship.
accord, learned counsel for the appellant with consent for the other side, first for listing the matter after vacation.
After vacation.
May it please your lordship. Lordship, this matter pertains to lordship has heard this matter regarding payment of arrears salary. Matter is disposed of. I have to file an I. Can this I be taken up tomorrow, lordship?
I for what purpose?
I for clarification of the duration of the interest to be counted. There is some difficulty in the order. They are not understanding it. So clarification is required from this court.
After vacation. Not tomorrow.
Please, your lordship.
May I please, lord. My lord, with due consent of the other side, my lord, item number 28.
28.
Yes, my lord, may be taken after vacation, my lord. The date may be fixed, my lord.
You are for appellant or respondent?
My lord, I am for respondent. My lord.
Respondent number?
Claimant. 1.
Mr.
Claimant.
Hussain.
A. Hussain.
A. Hussain,
Yes.
learned counsel. For the respondent number 1 and 2 with consent from the other side, first for listing the matter after vacation.
My lord, date may be fixed, my lord.
7th August.
No, please, lordship. Lordship, on Monday, I made a mention for listing today, but it has not been listed. I've got the information that the concerned person is on leave. That's why it has not been listed. So can it be taken up tomorrow, lordship? Because the next date is fixed on Monday, lordship.
Tomorrow not possible.
So on Monday, lordship, on 30th.
Vacation months.
30th, lordship. The vacation is on 30th.
May it please, lordship. One item, it was mentioned on last Friday. I was for the petitioner. That was item number 21, my lord. I could not come at 10:30, my lord. Other side mentioned it. I had given them the consent that it may be come up on Monday or on Tuesday. Accordingly mentioned, your lordship also allowed. But it was similar to, I have seen from the message, my lord, it is listed after vacation on 22nd of July, my lord. One RFA with my IA. In the video, my lord, I have seen your lordship ultimately permitted after vacation on Tuesday. So that is my lord, that was 22nd.
Now what is your pair?
My lord, it may become immediately after vacation.
Which item? Yesterday item number?
No, list item number 20 of list dated, my lord, 20.
You first inform the other side.
Yes, my lord. I'll inform
then we
because
will consider.
they are respondent. I'm the petitioner.
No, maybe
They mentioned. I'll
you
inform them.
obtain their consent that we should list the matter immediately after vacation. Only then we will consider. Yes.
Please, your lordship.
Yes, my
Lordship, with the consent of the other side, I beg to mention item number 26.
Item 26.
Your lordship, let the matter be listed in the month of August, your lordship.
You are for
The petitioner, your lordship.
petitioner. Mr. Your good name?
C. Buraguhai.
C. Buragohai, learned counsel for the petitioner with petitioner or appellant
Appellant, your lordship.
with consent from the other side, press for listing the matter. When?
In the month of August, your lordship.
In the month of August.
Lordship, we have some urgency if a date may be fixed in
When?
any date as per the convenience.
Okay.
On 8th August.
Lordship.
May, please, your lordship. Sorry. With the consent of the other side, my lord, may I pray item number 24 be listed immediately on reopening, my lord. Some
When?
persons have died on reopening, my lord.
Reopening.
Reopening.
Mr. Bornick, learned counsel for the appellant with consent from the other side, press for listing the matter after petition.
After, my lord, a date may be
Reopening of
given.
the petition. Immediately after reopening of the petition. Fair allowed.
I'll make a mention for that. Obliged, lordship.
Item to be spoken to, item number 32.
After some time, let the other side come.
For motion, item number 1.
May to the lordship.
Yes.
This is a petition for transfer of a divorce matter from Kasar to Sri Bhumi, lordship. I am
Kasar
for the
to-
wife,
Kasartam,
Sri Bhumi, Borington, lordship.
what is the distance?
Lordship, it will be more than 50 kilometers, but problem is that the petitioner here and the wife, she is suffering from some neurological disease, she cannot travel. That is number one. Secondly, she is in charge of a post office. Lordship, I have annexed the document, so she cannot leave the station without leave her monthly, lordship. Page 19 and annexer D,
Page number 19.
19, lordship. Certificate in the office, in charge of the office SPM, Tilabazar SO, IPO Nil, was relinquished.
So where is the medical document to show that she has
Okay,
been
that-
suffering from neurological problem?
That medical document I had not, was not available with me at that time. Lordship, because, the main point is that she cannot leave the station of her official duty, lordship. So,
Mr. R. Sharma, learned counsel for the petitioner. This petition under section 24 of the Code of Civil Procedure is preferred by the petitioner, who is the petitioner for transferring of FC within bracket civil number 068 of 2024 pending before the Court of Learned Principals as Family Court Kasar Silsor to the Court of Learned Districts as Sribhumi. Mr. Sharma, learned counsel for the petitioner, submits that the FC civil case number 068 of 2024 is instituted by the respondent hearing, who happens to be the husband of the petitioner. And that the petitioner is serving as in charge of one post office.
yes.
Tilabazar Post Office, Kasar Sirisur. And besides, she has been suffering from some urological problem, and she is not in a position to attend the aforementioned, to contest the aforementioned proceeding at Sribhumi. No, at Sribhumi. No, at Kasar, at Kasar. At Kasar, can assess Mr. Sharma contended to allow this petition by transferring FC Civil number 468 of 2024 pending before the Court of Learned Principal Judge Family Court Kasar Sitsor to the Court of Learned District Judge Srivani. The submission of Mr. Sharma needs further consideration. That is his notice be issued to the respondent, the attorney will in 4 weeks, that be taken by registered post with AD and also by usual process is to that. And further considering the submission of Mr. Sharma, and also considering the documents plus on record, this court is now further proceeding of FC civil case number 468 of 2024 pending before the Court of Learned Principal Judge Family Court Kasar Sitsor since the state will be returnable day. List after 4 weeks.
Obliged.
Number,
My lord, let this matter be taken up after some time, my lord. My senior is at lakes and 4 number 2. Obliged.
item number 3,
Let, my lord, if your lordship should see the judgment passed by this honorable court, my lord, which starts from 89, but I'm doing your lordship's attention at page 108, my lord. 108. 108.
Page number 100.
8. 108. Paragraph 28. Paragraph 28, your lordship. Before concluding this court, would however like to clarify the decree so passed by the trial court is a final decree within the meaning of order 20 rule 18(1) of the code, thereby directing the collector to carry out the partition in terms of section 54 to the extent as decreed by the trial court. The plaintiff's right title interest is declared so far. The 3 bigha 4 katha 6 shatak 6 kanda 3 kora of the suit patha and collector or any person designated by him in terms of section 54 of the code, read with provisions of Assam Land Revenue Regulation, shall partition the suit patha as per the decree passed by the trial court and amicable settlement so far as title appeal number so and so are concerned, and thereafter issue a separate patha in favor of the plaintiff, appellant to the extent decreed by trial. So, my lord, this matter is virtually, my lord, the executing court is to send the same to the collector, my lord, virtually for partition. Now we filed a, my lord, the execution case. If you will still find at page 111, my lord, this was filed on 8th of August 2024. My lord, and they are filing petition one after another, my lord, the other side. My lord, your lordship knows, my lord, the Supreme Court, the judgment, my lord, that Supreme Court has somehow to curtail the execution, my lord. Until the delay in execution, my lord, passed this judgment by 3 judges bench of the Supreme Court, my lord.
No, that's all right. Why don't you place this judgment before the?
We have placed, my lord. We have placed, my lord. My lord, this is, my lord, delayed for last 1 year, and we have also said, my lord, that they are disputing only dag number 1 and 2. Other dags are not on dispute, my lord. But here partition, my lord, at the time of
Mr. Savayala,
yes,
very recently, Supreme Court has issued direction that the execution case shall be disposed of within 6 months.
my lord,
We find out that judgment.
which one?
Execution case has to be disposed of within 6
months.
6 months.
6 months. This is the judgment by the Supreme Court.
Which one?
This one. I have submitted to you.
No. Recently.
Oh, here.
No, recently.
This year. What is that judgment? We will see.
Your lordship passed it, my lord.
No. Supreme Court has passed the judgment
Achha.
that execution proceeding has to be completed within 6 months.
Yes, this is also same, my lord, online.
Maybe,
Three judgments.
no, but some other directions are also there in that judgment. What is that judgment?
Let it come tomorrow then.
Tomorrow may not.
My lord, only this point, my lord, your losses will directly send up back to the trial court. Your losses today also it can be done, my lord.
Produce the judgment, we will see.
Tomorrow. Tomorrow I shall produce.
As this is the matter tomorrow for further consideration.
My lord.
Number 33. 33 for motion.
None appears for the prisoner on call. This is the matter of her petition.
34.
Wait, please, yes, my lord. But here in this case, my lord, the plaintiffs filed a suit for declaration of right title interest on the basis of inheritance and partition. Against that, my lord, the defendants, that is the respondents, my lord, they filed a counterclaim also. So, my lord, if my lord sees schedule of the plain at page number 32. Here, my lord, the land, page 32. The land is covered, my lord, by Pargon Moza Superkande. And so, my lord, the Moza that is involved is Suprakande. In the counterclaim also, my lord, that is at page number 52 schedule, Moza is Suprakande, my lord. During the pendency of the suit, my lord, the defendant numbers 1 to 5, they filed a petition. That petition will, my lord, will find at page number 71. What happened was that, my lord, the land was acquired by the government, some different land, not connected with the present suit. Land covered by Moza Lokhar Khai, my lord.
But it is in the same Moza.
Same, not same Moza, my lord. That was, the land was acquired in Lakhar Khandi, and now the land involved herein is Super Khai. So completely different Mozas. So what has happened is that, my lord, they filed this petition not to disburse the compensation amount before by the collector, my lord. And accordingly, my lord, on the very same date of filing of the petition, this order was passed, my lord, 28 to 2025, without giving any opportunity to the plaintiff to file their objection or to raise any objection.
Page number.
Page number 75. Last paragraph I'm reading, my lord. In view of the extreme urgency, this order is passed without hearing the plaintiff, as non-granting of immediate relief may render the suit infructuous and lead to injustice. Next page, my lord. However, such an order does not cause prejudice to the plaintiff since the matter remains sub judice before the court. Accordingly, District Commissioner Siribhumi is directed not to disburse the compensation amount to any person until further orders. So thereafter, my lord, what happened? Immediately the petitioner, along with the plaintiffs, they filed this petition, next page, my lord, 77. To reconsider the order dated 28 to 2025. Thereafter, my lord, the impugn order was passed. That, my lord, will find at page number 91. The operating portion is at page number 92, last page, my lord. Upon consideration of the pleadings and materials placed on record, it is evident that the validity of deed number 2978 dated has been challenged in the instance suit. The said deed includes land covered by DAG number 290. Although the DAG number is not explicitly mentioned in the schedule of the pleadings, the connection between the impugned deed and the DAG number in question is established through the Jamabandi record submitted by the defendant. It is settled principle that when a deed is challenged in a suit, that deed pertains to a particular land. Any order concerning the subject matter of the deed must include all the properties described therein. Therefore, until the issue of validity of the deed is adjudicated, any compensation relating to the land covered under said deed must be withheld to avoid prejudice to the outcome of the suit. My lord, my contention is not that whether the land falls in the DAG number or the subject matter of the suit. It is hit, the order passed by the learned court below is hit by section 63 of the right to fair compensation and transparency in land acquisition and rehabilitation. My lord may take up section 63, my lord. Because the jurisdiction of the very civil code is barred. Okay. In case of, my lord, compensation or the land acquired by collector. Section 60, my lord has got it. Section jurisdiction of civil codes barred. No civil code other than High Court under Article 226 or 227 of the Constitution of the Supreme Court shall have jurisdiction.
That's all right, but already one suit is pending before the trial court.
My lord, but suit is pending, but the land was acquired. So that is completely different subject matter, my lord. Land was acquired. So if any grievance is there by the defendants, my lord,
Land.
it was the collector. my-
Mr. Iqbal, the land acquired by the government is the subject matter of the suit. Right?
I'm not saying that it is the subject matter of the suit because the MOSA is completely different, my lord. That is one aspect of the matter, my lord. Secondly, my lord, even if it is assuming that, my lord, the land is involved in the subject matter, or it is a part of the subject matter of the suit, then, my lord, they can
Then
very
how
well,
this bar will come into play?
this bar will come into play only in the reason, my lord, because the compensation amount that has to be given or disbursed, my lord, that cannot be stayed by a civil court, my lord. It has to be done by the collector through a reference court, my lord.
No.
Section 63, my lord.
No,
It is very specific, my lord. No order of injunction can be granted. So injunction thereby meaning that, my lord, any restraining order cannot be passed.
No, court has not granted injunction beyond its jurisdiction because suit is pending before it.
But at least an opportunity has to be given, my lord. Without giving an opportunity on the very date of filing of the application, my lord, then.
No,
Please.
subsequently, you have filed an application and you have been heard.
I had filed an application, that is different thing, my lord, but
Then,
when the application was filed, no opportunity was given because I had raised the point that, my lord,
and why opportunity was not given, that has been explained in the order.
well, at least it could have been, my lord, after 2 days, let it come after 2 days, till then you can file an objection or something. But my main case is, my lord, section 63. That was not considered, even that was not placed also, that was. So my only limited prayer is that, my lord, let the matter go back. Let me file an application under section 63, my lord, saying this.
No,
need
no,
to
no,
notice,
no,
my lord.
no.
Otherwise, my lord,
I don't think that section 63 will come into play here. Yes, Mr. Gogoi?
Lordship, actually, what happened, Lordship, this petition, whatever my learned friend is submitting just before, Lordship, it is grossly mismatched, Lordship. I could not find as page number 70, 75, and etc. Grossly mismatched, Lordship. That's why I could not understand about the matter. Let him serve the proper copy.
We'll take it up in the second half. In the meantime, you furnish a copy to him. Right?
Lots.
bless me.
So additions, item 4, part method.
Lordship, here I pray for some accommodation, Lordship. It is under process, I am told, telephonically also, and they are going to pass the order within a day or two. So Lordship may immediately post this matter immediately after on reopening, Lordship. In the meantime, we will get some order.
No issue.
Heard Mr. M.A. Islam, learned counsel for the petitioner, and Mr. P.M. Sharma, learned standing counsel for the respondents in elementary department. Mr. Sharma tried for adjournment of the matter. As per his information, some developments are going on, and accordingly, he submits that the matter may be listed immediately after reopening of the petition. There is accordingly allowed, justice allows the matter after reopening of the petition.
Lordship, fix a date, madam.
On 18th July, items 5 and 6.
All right.
May it please, your Lordship. Your Lordship order dated 9/6/2025 may kindly be carried. Pursuant to your Lordship's order, Lordship, the district elementary education officer.
Lordship, this is that case, my lord, sorry for Islam, where Lordship had last time had given us directions to, everything was set, my lord. I've got my instructions. Kindly see, my lord.
Lordships, there was a mistake in the name of treasury officer.
Exactly, my lord.
Lordship, instead of treasury officer Bileshipara, Lordship, it was written treasury officer Dhubri. So that is clarified by the respondent of director, Lordship.
Yes, ma'am. That has been clarified. So what happened, my lord? The payment was supposed to be made, but then what happened? His treasury officer. No, my lord. It was supposed to be made, but his treasury officer was wrongly given as wrongly fixed as Dhubri instead of Bilasipara.
Yes.
So that has been rectified by a corrigendum, my lord, which I have given, my lord, in Lordship will see the last page, page number 8.
Of June, Lordship.
24th of June, my lord, where, my lord, a corrigendum has been issued and the rectification has been made. And, my lord, therefore, the process will start, my lord, for payment. So Lordship will have it after the vacation. In the meantime, his payment will be made. His treasury was shown
Okay,
wrong.
okay.
So that is why I mean, he knows it.
Yes.
Okay.
Otherwise, it is in process, man. His current salaries will be paid. The what he
And
had
regarding arrear?
arrear that will take some time because his NPA that he has to open an account in the NPS. Some formalities are there. So all that he's complying, he's cooperating. So that as soon as that is done, it will be paid.
Heard Mr. R. Islam, learned counsel for the petitioner, Mr. Popon, learned counsel for the respondent. Mr. Popon submits that. The matter may be listed immediately after reopening, and in the meantime, the current salary of the petitioner will be deposited in his account. It is accordingly allowed. This is the matter on COVID.
On 25th July.
25th July.
Can it be on the first week of August? Because why I'm saying these things take time, no, my lord. So now since
Status of current salary, Lordship may kindly prepone Lordship immediately after vacation.
that too will be done, my lord. Lordship will keep it in the first week of August, my lord, because these things take time. Already
No.
they have processed.
Only this treasury officer has already been changed.
Yes.
Treasury office.
The current salary has also been sanctioned now. Correct. I'm talking about the arrear, but the other one. The arrear will take some time.
Whether you will be able to make payment of the current salary or not.
25th July, my lord. 25th.
On
25th July.
25th July.
25th. Deeply obliged.
Letter produced before the court. Shall be part of the.
Perfect. Deeply obliged.
Item number 7, pattern matter.
In this case, your lordship, matter relates to payment of arrear DA, your lordship. Your
Arrear
lordship,
DA.
DA, your lordship has earlier, your lordship, kindly go through the earlier orders, your lordship, 2 orders, your lordship. They have been processing it, they are saying, your lordship. My prayer would be, your lordship, that since they have processing it, your lordship, unless there is a direction from this honorable court to ultimately take a call on this issue, your lordship, then matter will be, your lordship, they will take time, and your lordship has seen, your lordship has passed, have given time twice, your lordship. And therefore, a direction may be issued, your lordship, asking them to take a call on this issue, your lordship. Because they are saying that since long that they are processing it. And ultimately, so far as we, our instruction is, your lordship, finance also approved, your lordship. But why they have not taken a final decision, your lordship? That's
I have received the instruction. Now they have sought from some opinion from the learned advocate general.
Pardon?
Learned advocate general. They have sought opinion from him, madam. So may I please whenever we taken after vacation, madam, in the meantime, they can process, madam.
Or your
The
lordship,
opinion has to
they
be-
can,
Opinion from AZ.
Advocate, yes, madam. So
they can, your lordship, do it, your lordship, they can take opinion, but my prayer will be, your lordship, may direct them to take a decision within a particular period of specified period
Then
of
we
time.
will close the matter.
If by that way your lordship can close, or your lordship by directing them.
but very difficult on part of me to regarding disposal of the matter, well, since this under constitution of government, and now government has sought some opinion from the learned advocate general. So if my lord may direct for a consideration, then it's okay, my lord. But how it will be processed is difficult to say right now, my lord.
And it's your lordship will kindly see this matter is pending since 2020.
Mr. Khatonia, do you have any doubt that their pair may not be considered favorable?
No, my
by
lord.
the
No, my
government?
lord. I have no doubt about that, my lord, because
Then
now they have sought some opinions, my lord, regarding how it is processed, my lord. So may I plead that madam?
regarding
after-
payment of DA, why the opinion of AZ is necessary? It's a financial matter.
Exactly, my lord. Now finance department send back the file to the administrative department to take a decision. That is why they have sought some opinion from the learned advocate general.
Your lordship can go through the earlier instruction, your lordship. Apparently, your lordship finances, your lordship.
No, if the finance department has already given the concurrence, then where is the part?
No, my lord. Finance department, as per the letter from the government, my lord, regarding seeking opinion. Now, finance department relegate the matter to the administrative department to take a call. That is why, my lord, they have sought some opinion from the.
Where is that letter?
My lord,
Earlier letter is there, your lordship. Last occasion they have placed it before this honorable court.
No, regarding the letter by which they asked for the opinion
No,
from.
it is not with me. I have received yesterday, my lord. Copy is with me, my lord. I can give it. If my lord wants.
We'll see the letter. You produce a copy, you send it to the court person.
Yes, my lord. Right now, I am sending, my lord.
Mr. Bhattakur will take it at 2 p.m.
Lords.
We'll see the letter.
Lords.
Item 8.
Number 33, lordship, I have missed it, lordship. If your lordship pleases to take up this matter, item number 33 of the supplementary list, lordship. I have missed it. If your lordship fixes after vacation, can we take it?
Try as last item today.
Lordship,
Not now.
last item.
Yes.
Lordship, I need to, I've just noticed I need to make a correction here, Lordship.
Correction.
Yes, Lordship. In one place, in the first place, I have written right leg, but in the first para, I have written wrist. So if it is not corrected, it will create a problem.
In the memo of appeal.
Memo of appeal in a substantial question of law. In one place, there is a typing mistake, Lordship. I have wrote wrist in one place and right leg in one place.
Okay.
I need to correct it.
Mr. R. Goswami, learned counsel for the appellant submits that he may be granted some time to make necessary correction in the memo of appeal.
Yes, sir.
Memo of appeal. There is accordingly allowed. Recessal is the matter after reopening.
After reopening. 1 week after the reopening, because tomorrow from tomorrow it will be closed. That correction may not take place 1 week after the reopening.
1 week after the reopening.
Obligation.
This appeal is basically filed on the ground that deceased was a government employee. He died after notification of a government of Assam issued in 2017. And this issue has been settled by this court and the Supreme Court, that they are entitled only for the loss of estate, funeral expense. So
when the accident took place?
Accident occurred in 2018.
Pardon?
2018.
2018.
29/1/2018.
And when the government notification was issued?
Government notification is 14 September 2017.
2017. 17.
So in this particular case, this court as well as the Supreme Court has settled the matter. They are entitled for the only the lordship the conventional head. That is lordship amount of rupees 1,45,000. And Supreme Court lordship will rescind judgment in 2025. Again, reiterated the same principle. Para 9 is the written.
Mr. S.K. Goswami, learned counsel for the appellant. This appeal under section 173 of the Objection. It is directed against the judgment in our dated 29/1/2025 passed by the learned member motor accident claim tribunal number 1 Kamrup and Guwahati in MSC case number 748/2018. But Mr. Goswami, whether you have brought it to the notice of the tribunal?
Lordship. Lordship.
You have.
But recent judgment passed by the Supreme Court was not brought on record because it is 2025. And this honorable court also passed judgment on this point on MSC appeal number 261 of 22 by this honorable court.
Notification we have got.
And notification has been brought on record.
Yes, to be noted here that by the interim judgment and award dated so and so, the learned tribunal has directed the appellant hearing to pay a sum of rupees 46 lakhs.
46,61,029.
1,029.30 rupees. Bring the compensation to the claimant number 1. Claimant number 1. Peruse the memo of appeal and the grounds mentioned therein. Admit. Issue notice to the respondents. Returnable employees that be taken by registered post with AD and also by legal process. You can avoid that. Recessal call for the record from the learned tribunal is a matter of 4 weeks.
Lordship, we will deposit conventional at 2,29,900.
One caveat was.
Caveat was that Agorda was appearing. Air Agorda.
Yeah.
Well, it's been copied also. Already served.
Already served. You want to deposit?
2,29,900.
Why only 2 lakhs?
That is the under the conventional head tribunal has awarded. Page 33 of the judgment.
Page number?
Page number 33.
53. Heard Mr. S.K. Goswami, learned counsel for the applicant. This interlocutory application is prepared by the applicant for staying the judgment in award dated 29/1/2025 passed by the learned member not to exceed in claim terminal number 1, American Guwahati, in case number 7/48 of 2018. Mr. Goswami, learned counsel for the applicant submits that the learned tribunal has directed the appellant for payment of a sum of rupees 46 lakhs.
46,61,000. Total award.
$61,000 to 29.30 rupees. And further, Mr. Goswami submits that the petitioner was a government servant. Sorry. The deceased was a government servant. And as such, the claimant will entitle to only the entitled to compensation under the conventional head only. And that the applicant is ready to deposit 50% of the amount under the conventional head.
No, not 50%, Lordship. Total amount, 2,29,000.
2 lakh?
29,900.
2,29,000. 900. 900 before the registry of this court. And he also submits that till disposal of the MSC appeal, operation of the impugned judgment and award dated 29/1/2025 may be stayed. Taking note of the submission of Mr. Goswami, learned counsel for the applicant, and considering the facts and circumstances in the report, this interlocutory application stands allowed, subject to depositing the entire amount of 2,29,000 rupees being awarded under the conventional head. In terms of this ISS clause.
Within 6 weeks.
Within 4 weeks.
Obliged.
Item 10.
And that may be released also in favor of the claimant. That may be released in favor of the claimant also.
They are not before the court.
Lordship, that is my prayer, Lordship.
No.
Obliged.
Item 10.
None appears for the appellant on call is the matter after vacation.
For daily hearing, item 35.
None appears for the accused on call is the matter after vacation.
Items number 11 and 12. Items for hearing under order 41.
May I please, Your Lordship? Your Lordship, my senior is on lag in court number 3, so may pass over the matter for the time being. She will be arrive within 10 to 10 minutes.
Okay.
Obliged.
13.
May I please, Lordship? Lordship, the petitioner number 1 and his 3 brothers, namely Surendra Dhar, Narendra Dhar, and Manmohan Dhar, were landless person, my lord, farmers, and government of Assam decided to allot some sealing purpose land to the plaintiff number 1 and his 3 brothers on 26/6/1976, my lord, Annexure 1. Government of Assam had allotted 10 bigha 2 lessa 2 kotha 12 lessas of land. I died tag number 322 and 323. Page number 12 is the original copy, my lord, and page number 11 is the English translated type copy, my lord. Where is his 3 brothers and including plaintiff number 1 name has been included, my lord. In the year 1984, my lord, there has been a family arrangement, and his 3 brothers decided to relinquish their share of land and left the place, my lord. And they shifted to Bhotiali, near another district, my lord. And the petitioner number 1 possessed the land, my lord. These are some photographs, my lord, where the petitioner number 1 had enjoyed the land with cultivation and make his dwelling house, my lord. Thereafter, the respondents were the neighbor of the petitioner, my lord, and they repeatedly trying to encroach the land, and they filed a 145 proceeding, my lord, before the executive magistrate. And on 31st July 2021, the concerned Latmandal and circle officer
Mr.
issued
Counsel,
dispersion.
you have suggested as many as 6 substantial question of law.
My lord.
You tell me which one is in which question the substantial question of law is involved.
My lord. I'll go through, my lord. My lord, point number 1. Whether the first appellate court was legally right in not considering the fact of in the revenue record, it is clearly stated that suit land stands in the name of plaintiff petitioner number 1. My lord, this is the revenue report, my lord. Position report.
Whether any question of law is involved herein?
My lord. My lord. Point number 2.
What question of law is involved herein?
My lord, point number 3 on 20.
Is question of law or question of fact?
Question of fact, my lord.
Fact,
my lord.
Whether sitting in second appeal, this court can appreciate the fact.
My lord, has the learned trial court passed an interim order in favor of us while pending the title.
First you tell me whether dealing with an appeal under section 100, this court can appreciate the facts.
My lord, there are substantial question of law was framed, has to be framed, my lord. My lord, point number 5, the substantial question of law as to whether the first appellate court has decided itself decided as if it is a preliminary issue where no preliminary issues were framed, my lord. No preliminary issues were framed. My lord, point number 4, the substantial question of law as to whether the first appellate court ought to have considered the rejection of Miss Case number 27/22 has left the appeal totally unadjudicated, and thereby the right to enjoy their landed property of the appellants have been denied, my lord. My lord, we have been positioned for last 49 years, my lord. And title suit is pending, my lord. Since title suit is pending, the first appellate court denied our position right and gave the interim position to the opposite party, my lord. My lord, we have paying revenue since 49 years, my lord. and revenue receipt has been also included, my lord. Government of Assam allotted the land to us, my lord. We are cultivating the land for 49 years, my lord, and we are paying revenue regularly, my lord.
I am giving you one judgment.
My lord.
You take down.
My lord.
Narayanam, Rajendran and another versus Lakshmi, Sarojini and others.
My lord.
Civil appeal number 742 of 2001. Reported in 2009, 5 SCC 264.
My lord.
You go through the paragraph number 37.
37.
And thereafter you come prepared.
My lord.
What substantial question of law is involved in this appeal?
My lord.
We will list it immediately after reopening.
My lord, at this stage, we are only praying for the stay of the that
No,
appeal order, my lord.
unless the appeal is admitted, we cannot pass such order. First, we have to admit the appeal. Only thereafter we will consider your entering there.
My lord.
Pardon me, sir.
M.H. Suika, my lord.
Learned counsel, I fell. List immediately after reopening of the petition for further consideration.
My lord, that will fix, my lord. My lord, kindly that will fix, my lord.
23rd July.
Obliged, my lord.
Number 36.
May I please, Your Honor, the matter we pass over for the time being, Your Honor. Senior is another court. Sorry.
At number 14 for orders. May I please, Your Worship?
Lord, I may be allowed to file an objection to this. An objection. One.
You will file.
My lord, the problem is there because yesterday the case was fixed before executing court and the executing court has fixed tomorrow. And they have appeared on 10th of April itself. Till this, they have not filed any objection. Now, my lord, the executing court will not.
In fact, my lord, sale deed is already executed by the executive. Sale deed has already been executed. It was a decree for specific performance, my lord. The appeal suit was decreed, my lord, appeal preferred by them. Appeal got dismissed for default, my lord. Thereafter, we pursued execution, my lord. Sale deed has already been executed in terms of the decree by the court.
Still decree is going on because of my dispossession, my lord. That is the problem.
No, if decree is already executed, then what remains?
Then, my lord, if my appeal is allowed, then extra 154 is there.
Will happen, my lord. So therefore, if they succeed in the restoration and thereafter in the appeal, then they can file for restitution, my lord.
You inform the trial court that one appeal is pending before this court.
They themselves say, because they are insisting. They are insisting.
The court. Both of us have informed the court that the appeal has been dismissed and the restoration has been is pending.
Only because if,
when you will be able to file objection?
Right after vacation, my lord. Right on reopening.
But Kaile যদি একতা insist করে হেঁটেও problem হয়েছে because the counsel appearing there
You do one thing, you file an application there.
My
that one RFA is pending before this court along with an interlocutory.
The date has already been informed, my lord. Yesterday the case was, my lord, fixed and you taken up, and the executive court has fixed tomorrow because of today's listing, my lord. And my lord, my ground is that earlier erstwhile counsel.
In that case, my lord, may I pray, my lord, let the restoration be allowed, my lord. It's a suit of the decree of 2015, my lord. So right after reopening,
yes.
Your lordship.
Here, yes, that can be done.
My lord may not say I have not objected, but your lordship can allow. And I just pray for a fixed date for hearing.
Restoration means?
The appeal got dismissed for non-prosecution.
This one?
Yes, RFA is no longer pending, my lord. They filed the IA for readmission. In the meanwhile, the decree was executed by.
Should be there.
জুলাই মাসে কনসিডার করে অগস্ট ফার্স্ট
It was dismissed on 21/3/23. IA 3/4.
I is for condonation of delay.
One condemnation
Yeah.
to delay and one for restoration.
So you have no objection then.
My lord, will readmit. My only prayer is, since it's an old pending matter, we'll fix it for hearing right afterwards.
And what is the ground for this delay?
Yes, ma'am. Actually, what happened earlier, B. Banerjee was conducting the case.
Oh,
B. Banerjee, senior counsel B. Banerjee, he was conducting the case and he expired. And this fact was not known to them. When they have gotten notice from the executing court, only then they come to know that their counsel has expired. And thereafter, immediately it was filed without.
Mr. Sahul learned counsel for the applicant and Mr. B.D. Data learned counsel for the respondent. Yes, I number 3OW. Is interlocutor application under section 5 of the Limitation Act is prepared by the applicant for condemnation of delay of 127 days and prepared restoration application. In RFN number 59 of 2015. Mr. Sahul learned counsel for the applicant submits that RFN number 59 of 2015 was dismissed for non-prosecution on 21/3/2023. 2023, and that the earlier conducting counsel of the applicant suffered demise, for who is the application could not be filed in time, and that the delay is not intentional or whether it is circumstantial, and therefore it is contended to allow the petition. Mr. Detta learned counsel for the respondent opposite party submits that he has no objection. Further, taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances of the record, this interlocutory application is then allowed. Since the delay of 127 days is sufficiently explained, the same is then condemned. FC case number 86 of 2023. Heard Mr. Sahul, learned counsel for the applicant. And also heard Mr. B.D. Deka, learned counsel for the respondent. Opposite party. This application under order 41 rule 19 of the CPC referred by the applicant for restoration of RFN number 59 of 2015, which was dismissed for non-prosecution on 21/3/2023 by this court. Mr. Sahul, learned counsel for the applicant submits that on account of date of the earlier counsel, the application could not be filed in time and the delay filed in time and the applicant could not take step within the stipulated period, and there is a requirement for restoring the RFN number 59 of 2015. Mr. Deka submits that he has no objection in restoring the RFN number 59 of 2015. However, Mr. Deka submits that since the matter is of the year 2015, a date may be fixed for hearing of the matter. By taking note of the submission of learned counsel for both the parties, this application is then allowed. RFN number 59 of 2015 is then restored to the file. Since the RFN number 59 of 59 is of the year 2015, this is always the matter. 14th of August for hearing.
Item 15.
May I please, Lordship, I am sorry, Lordship, item number 35, Lordship. Just matter, I missed out the matter, Lordship. Finally, Lordship, taken bail hearing, Lordship. I thought that Lordship matter will be taken up. Not now. Really, After, Lordship. as last item, we will try.
As last time.
As last, Lordship, Oblige, Lordship, oblige.
Paper book to.
Oh, I know.
Well, the paper book is also ready, you know, that the LCR also come.
LCR came. Service is also completed, Lordship, in this case.
Ready for hearing.
It's not yet admitted, so it may be admitted and.
Paper book to তোমাক দিছে
নাই দিয়া, paper book নাই।
তুমি বলেছে
নাই, paper book নাই।
not paper book is not required. Everything is required, but your lordship may now fix the matter for hearing.
First have to admit because it's not yet admitted.
Pardon me, Sarma, learned counsel for the applicant, Mr. P. Boda, learned senior counsel assisted by Ms. K. Bhattacharya, learned counsel for the applicant, respondent. It is submitted at the bar that the matter may be admitted and it may be fixed for hearing after vacation. There is accordingly allowed process unless the matter suggested it.
Well, convenient to lordship,
19th August.
my lord.
There is an interim, Lordship.
Interim order pass earlier.
Obliged, Lordship.
Item 16.
Pass over for the timing also. This comes in on less also. Pass over for the timing also. Can be taken up at 2 also. At 2.
Will say not exactly at 2, Lordship. I have some other cases also. As per convenience, actually inform the court master, Lordship, whenever it may be taken up. If
Okay.
On convenience, we
May it please your lordship. My lord, in this case, a notice was issued, my lord, earlier. My learned friend has appeared. But my lord, appeal has not been admitted, my lord. Yet, my lord.
So let this matter come up for order 41 hearing, my lord. Let this matter be taken up for order 41 hearing, my lord, because appeal is yet to be admitted. Substantial questions have not been formulated as such.
My lord,
I is for what purpose?
I is for my lord, stay of the execution case, my lord. There is the execution going on, my lord.
Unless the RSI is admitted then.
My lord, earlier your lordship pleased to file additional affidavit regarding, my lord, my question of law, substantive question of law, my lord. I have already submitted that affidavit, my lord. So lordship may kindly consider, my lord, and appeal may be admitted, my lord, because, my lord, in the, my lord, learned trial court, my lord, the title suit was, my lord, dismissed against me, my lord. I have filed the counter claim, which was also dismissed, my lord. Thereafter, my lord, some delay was there. And delay petition was filed for the, my lord, restoration of appeal, my lord. But that petition was rejected, my lord. So on the ground of the delay, my appeal was dismissed, my lord, and for which I approached before this honorable court filing this second appeal, my lord. And earlier lordship was pleased to, my lord, allowed to file additional affidavit regarding, my lord, the reason of delay. And
When did you file?
I have already filed, my lord, is a record, my lord, I think. It was filed on, my lord, 5th day of December 2024. Your lordship was directed by order dated, my lord, 25/11/2024. Substantial question of law is 9, my lord, of my mayor.
No, affidavit is not available on the record. Huh?
But my only prayer is that, my lord, can this matter, my lord, be taken up for order 41 hearing, my lord, immediately after reopening, my lord, any day, my lord.
Oh, hearing.
Hearing on the order 41, my lord. 15, 16, any day, my lord.
Coordinate bench has issued notice, my lord. Actually, that was.
No, maybe.
Yes.
Unless the appeal is admitted, notice
Yes, ma'am,
cannot be
that's-
issued.
That is correct, my lord. As per your lordship order, my lord, we have filed an additional affidavit. Yes. In e-court record, my lord, is shown, my lord.
Okay. Additional affidavit.
Lordship, fix
What
that.
is the date of additional affidavit?
It is
2012, sorry.
5/12/2024.
No, that is not available.
Can it be at 2, my lord?
Okay.
Check. Okay. Hello. Obliged.
May it please your lordship. Lordship, this is a delay petition. As per the office note, lordship, Karatnama filed by respondent 1. And for 2 and 3, no AD card or unserved notice, lordship. But 2 is wife of 1, lordship.
I'm for opinion number 1, lordship.
You are appealing?
Yes. And lordship 58.
Oh, 1 and 2.
Yeah, I have no objection. It
Condonation
delay is
delay.
gone, lordship.
Okay. Heard Miss R.D. November, learned counsel for the applicant, and also heard Mr.
A. Hassan.
A.
Hassan.
Hassan, learned counsel for respondent. This application under section 173 of the MBA, created 65 of the Limitation Act 1963 is referred by the applicant for condonation of delay of how many days?
58. 58.
58 days in preparing the MSC, connected MSC appeal against the judgment and award dated 2/3/2024, passed by the learned additional member MSCT number 2, Tinchukia, in MSC case number 47 of 2021. Ms. Mozumdar, learned counsel for the applicant, step. What is the ground for delay?
Lordship, after the judgment was passed, Lordship, we employed an investigator to claim on the, because Lordship, here what happened? The claimant is the father, owner of the vehicle is the mother, and the deceased was the son, Lordship. And in the criminal case, the claimant has said that there was no fault on the part of the driver of the vehicle and all that. That, collecting that evidence, the delay was caused, Lordship. That we have mentioned in paragraph 4, 5, 6, 7, Lordship. That is the reason of delay.
Ms. Mozumdar submits that an investigator was appointed to investigate regarding the criminal case filed against the driver. In PLC case number 519 of 2022. And also on account of obtaining approval from the regional office. The appeal could not be filed in time, and the delay is not intentional, rather it is circumstantial, and the appeal has to be admitted and to be heard on merit, and accordingly is contented to allow the petition. On the other hand, learned counsel for the respondent submits that he has no objection in the event of condoning the delay. Taking note of the submission of learned counsel for both the parties and also considering the explanations of forthcoming for the delay of 58 days. This court is of the view that the delay is sufficiently explained and accordingly the same is since conduct. And this interlocutory application is accordingly allowed.
Lordship, can the appeal be listed in the vacation bench, Lordship? Because Lordship, they are pursuing a Bakija proceeding. Or else, Lordship, they won't pursue it and it can come after vacation.
In view of the order passing I number so and so, now the registry will proceed to register the appeal and to list the same before the court.
No, Lordship,
Why
it won't be
vacation
there.
bench?
Lordship, because they are pursuing a Bakija proceeding in
Not
the.
before vacation bench.
Uh,
Regular
no,
bench.
no, he won't be there. So, okay, Lordship, let it come after vacation.
Early after reopening.
Item 19.
Highly obliged.
May I please, Lordship, the IA is for continuation of 390 days delay in filing the accompanied LA appeal, Lordship. Since it is an appeal by the department, Lordship, some amount of delay has caused in filing this appeal. Lordship. It was for Borniha Tetelia railway line, Lordship, and in 2012 itself, the compensation has been paid around 68 lakhs. And in the reference case, Lordship, the respondent could not prove any documents, Lordship, to establish the fact that the land value was more than what he has been paid at the time of acquisition. In spite of that, Lordship, the enhancement has been allowed. Earlier,
Why the appeal could not be filed in time?
Lordship, some amount of delays caused in the.
Pardon?
Lordship, it needs some time in consideration of and approval of the different authorities, the department, Lordship, so some amount of delay has caused, Lordship.
Approval from different authorities.
Lordship, it needs.
And
My lord, we have filed our objection also, my lord.
plus letter complete.
Yes, Lordship.
In which paragraph of your affidavit, in your application, you have explained it?
Lordship,
Paragraph number?
Lordship, 4, 5, 6, 7, Lordship. 8.
Yes, what is the objection?
Yes, my lord. My lord, this is a case of total non-explanation and without any sufficient reason for condonation of delay of long 390 days, my lord. My lord, they have not stated in their application the manner, the procedure they followed for during the preparation of the appeal, for preparation of the appeal, stage by stage. Nothing is there in the application. That they have not mentioned even the date of receipt of the certified copy also. Your lordship may kindly look into their application. There is no date when they got the certified copy. when it was submitted to the authority for getting approval, nothing is there. That such and such time was taken by the such and such officer for giving the approval. Nothing is mentioned here. No date when the case was handed over to the lawyer. That is also not there. No any requirement as required under the section 5 of the Limitation Act to acquire satisfaction by the Honorable Court that there were sufficient reason, sufficient explanation, sufficient for condonation of the delay matter. Nothing is there. Nothing is there. They have not, from the copy appeal memo, they have furnished a copy of the appeal memo also before, along with the stay petition, along with this petition, limitation petition. That we have seen that the certified copy was received by them on 6 to 24. The judgment was of 22nd January 24. So immediately within about 15 days, they got the certified copy. So how they proceeded after getting the certified copy, nothing is mentioned in the petition. That after getting of the certified copy, we submitted it to the our authority for according necessary. Definitely there is procedure. There is administrative procedure, but only because of administrative procedure, it is a department's case. Administrative procedure is there. Procedure is there to prepare the get approval of the appeal is not sufficient reason for the purpose of section 5 of the Limitation Act, my lord. Nothing is there in the petition. They have not at all mentioned, not a single day, that on such that case was handed over to the lawyer for preparation of the appeal. Lawyer took such time, such and such days for this and that reason. Nothing is there. Even that after waiting for more than 10 months, your honor, after period of limitation is over, we filed the execution case, my lord. In the execution case, they immediately appeared after getting the notice. In the execution case, they appeared on 12/3/25, my lord. We filed the execution on 11 February 25 after waiting for more than 10 months. After the period of limitation is over, that is 90 days. We waited the limitation period. Thereafter again 10 months. Thereafter we filed the execution case on 11 February 25, my lord. Then the learned executing court fixed next date on 12/3/25. They appeared on 12/3/25. The learned and submitted application for filing objection in the execution case, although there is no such procedure. But the learned executing court was kind enough to grant them time, fixing next date on 27/3/25 for filing their objection. On 27/3/25, no objection. They filed an application. Learned trial court, the executing court was inclined to inclined to grant them time, and their application was rejected, referring to the Supreme Court judgment that the execution cases are to be disposed of within 6 months, my lord. That 27/3/25 order I could not annex because there was something wrong during the time of filing of my objection. It was not available with us. We have subsequently obtained. After this order also, my lord, your lordship may kindly look into that order.
And what happened on 15th of May 2025?
My lord.
Whether the writ was executed?
Not executed, my lord. We took these steps. No, not executed, my lord. But after that order also, my lord, they waited more than 1 month, 24 days for filing the appeal. After that order also. Nothing explanation. Even after that order also, my lord. So it is a question of, there is a mandatory provision. The limitation is not so much casual thing, my lord. There must be, and it is a department. There is a strong department, railway department special, my lord. So they ought to have been so much cautious for the limitation. And having come to know about the judgment, everything, they are all along present in the proceeding. Had there been a case of absence without knowledge, that would have been a different thing. But they are all along present. They were present at the time of passing the judgment. And even after that order also, 27/3, they spent more than 1 month, 24 days without any explanation. This is the position. That is why I have submitted before lordship before Lordship that it is a complete case of non-explanation and without sufficient reason for condonation of the delay, long delay of 390 days. There are so many cases, my lord. I like to draw your Lordship's kind reference to only 4 case laws, one decided by the Honorable Apex Court and three other cases decided by our Honorable High Court, my lord. How did you, only because of administrative reason, speaking that there is administrative reason, it is a department case, time is necessary. That is not at all sufficient. In all these cases, my lord, it is clearly held. This first case is of 1998 Supreme Court case, my lord. Case, this judge had not seen, my lord, limitation section 5, delay. Condonation of law of limitation has to be applied with all its rigor prescribed by statute. Courts have no power to extend period of limitation on equitable grounds. No equitable ground should come here, man. No equitable ground that they will suffer hardship like that. Nothing else. If they are not cautious, they are quite negligent, then they are not entitled for any equitable reason. Here this appeal was barred by 565 days. Last paragraph 6 is very much important, man, of that judgment. Paragraph 6, last paragraph, my lord. Law of limitation may harshly affect a particular party, but it has to be applied with all its rigor. When the statute so prescribed and the courts have no power to extend the period of limitation on equitable grounds. The discretion exercised by the High Court was thus neither proper nor judicious. High Court allowed this, but Apex Court rejected. Judicial. The order condoning the delay cannot be sustained. This appeal therefore succeeds and the impugned order is set aside. Consequently, application for condonation of delay filed in the High Court would stand rejected and the miscellaneous appeal shall stand dismissed as barred by law, my lord. That is. So there, in paragraph 5, it has been mentioned, my lord, in that judgment. This can hardly be said to be a reasonable, satisfactory, or even a proper explanation for seeking condonation of delay. The reply, it is also a case of, it is a state appeal. It was a state appeal, my lord. State of Kerala. State appeal. Here also the reason of administrative reason was taken. Here it was mentioned in paragraph 4 that at that time the Advocate General Office was fed up with so many arbitrations.
Not necessary to read out all those decisions. The law is well settled.
Yes, my lord.
Anyway, we'll pass the order.
Lordship, there is also some.
There is
also some judgment, Lordship, regarding delay on by the state, Lordship.
Okay, we'll see. We'll pass the order.
My lord. Of the Honorable High Court, 3 judgments are here. My lord, division bench judgment, 2 division bench judgments.
While the law is settled by Supreme Court, where is the question for High Court judgments?
It is a recent judgment, Lordship.
It is a case of gross negligence and without any explanation.
Okay. What is it for? Respondent number 4. Okay.
Paragraph number has been written. But on if there is merit on the matter, Lordship, on technical ground only, it cannot be.
If explanation is there, whatever may be, there should be explanation.
Okay, we'll take.
That's it.
Much obliged.
Item 20.
May it please your lordship. Your lordship, this matter has come up for the first time. There has been a delay of 20 days in filing the appeal.
After 4 weeks.
21.
Wait, please, your lordship. Listed for the first time, lordship, delay of 50 days.
60.
50 days.
Okay.
Much.
22.
May I please, your lordship? Your lordship, this is an interlocutory application praying for condonation of delay of 10 days in preferring the miscellaneous first appeal.
Okay, we'll issue notice.
Your lordship, the the Union of India is also present, your lordship.
Pardon?
The Union of India is also present. Your lordship, this matter is only for 10 days of delay. Perhaps the delay may be condoned, your lordship.
Maybe someone else has been appearing in this matter, Lordship.
Your lordship.
I have not.
This matter has come up for the first time, your lordship.
Whether you serve copy to her?
Yes, your lordship. Sure. Copies have been served to the councils of the Union of India, your lordship. Their name has also been reflected.
No, unless Her name. Her name has
No,
been reflected.
no, the Deputy Solicitor General of India's name has been reflected in the cause list, Your Lordship.
But we cannot compel her to.
Yes, Your Lordship. Yes, Your Lordship. Pardon me, Your Lordship.
We will issue notice.
Yes, Your Lordship.
You take a step within 1 week from today.
Yes, Your Lordship.
Next.
Much obliged, Your Lordship.
This is an application, Lordship, for condonation of delay of 31 days in filing appeal, Lordship.
31
days, 31 days.
31 days. Okay.
Lordship, my prayer is that in the cause list, in appeal, some other advocate's name has been reflected. In this case, my name has been reflected, but in appeal.
You go and file an application before the race day. We cannot do the work of race day.
Pending matters. To be spoken to matter, item 32.
Lordship.
I am.
Mr. Mukherjee. In the application, you have mentioned that you have engaged Mr. S.S. Sharma, senior counsel, and as his name was not reflected in the cause list, on 10/4/2023, Mr. Sharma could not appear. Right? That is your contention.
That was correct.
But you tell me,
The wakalatnama was not there.
when the wakalatnama of Mr. Sharma was filed,
I tried to trace it there, Your Lordship. The wakalatnama was not there in the record.
then why? How we can believe your statement?
Because later on another wakalatnama was filed along with the restoration petition, Your Lordship. Because this wakalatnama
This wakalatnama is updated 23rd of May 2023, more than 1 month after passing after dismissal of the.
That wakalatnama was filed along with the restoration petition itself, Your Lordship. The previous wakalatnama I tried to trace from the record on the previous date. I could not find it, Your Lordship.
Then
that is the fact. And otherwise also senior advocates wakalatnama is not required, Your Lordship. We can appear without a wakalatnama.
No. Your specific plea is that the name of senior counsel has not been reflected.
Not been reflected.
But you saw whether on that day he was engaged here or not.
No, Lordship, I have tried to trace it on the previous date itself.
Then we are dismissing the petition along with cost.
Lordship,
Dear my lord, one thing is also my lord. Here, my lord, one submission also from my side, my lord. In paragraph, at page 9, paragraph 7, they shown that I have my client has expired. Though he is alive.
Yes, we have taken note of the same also.
Coming item 2 for motion.
That statement is not correct.
Not correct.
Coming item 2 of motion.
I'm sorry, in the morning I was not here.
No problem.
My lord has already heard that matter on last occasion. And the only thing, my lord, I want to show your lordship, the cross-examination of the commissioner, my lord, what he has stated, because we filed an objection regarding the second commission. And at page 90, my lord.
But Mr. Chakraborty, the second commission was appointed on the pair being made by you.
Yes, we filed, no, we filed objection against the first commission. Against our objection was allowed.
Was appointed.
Yes, allowed. And second commissioner was appointed, my lord, by order dated 11/3/2020, my lord. Yes. Then, my lord, the second commissioner again, my lord, submitted his report, my lord. Of course, not, my lord, observing the guidelines given by the earlier court, my lord, by the earlier order. That earlier order, my lord, at 11/4/2023, page 62. When we file objection against the first commission, then some guidelines were issued by the honorable court, my lord. And there's, according to those guidelines, my lord, he was to take measurement of the suit part along with the defendant's plots of land, my lord, by meets and bounds. So that is not done by him, my lord. He only relied on the report submitted by the circle officer along with the lot mandal. And lot mandal said, my lord, that I had taken measurement only on the basis of the Jomabandi records. And kindly come to the page 90. We had cross-examined him, my lord. Relevant is 91, my lord. Point 7. Each and every land of each party was measured separately on length and breadth. After measuring the length and breadth of the said land, the same was noted down in a sheet of paper. But I did not note down the measurement of length and breadth of each of the parties of my own in paper. On the sheet of paper, no signature of the parties was obtained by me, where measurement of length and breadth were noted down by the concerned lot mandal. Then, my lord, few lines below, my lord, the report submitted by me is based on the report prepared by the concerned lot mandal and circle officer, and I have no personal comment on the said commission report. So, my lord, he did not apply his mind. So he did not, my lord, why he was sent for the, my lord, at the spot, my lord. He was to note down the things, my lord, so that he can produce before the trial court. And, my lord, next page, 92, my lord. In the trace map, the length and breadth of the land of each of the parties were not mentioned. And in the trace map, my lord, this is not the trace map based on the lot mandal's report, but there was a trace map prepared on the spot. So it is, it states about that. In the trace map, the length and breadth of the land of each parties were not mentioned. And the exhibit 3, X3, no length and breadth of the land of each of the parties are mentioned. So, my lord, if that is not done, if the measurement was not done not by meets and bounds, then what is this report, my lord? My prayer, my lord, in the pleadings is to find out the encroachment, my lord, because I have pleaded that the suit part which I have been using to my homestead land since 1973 has been encroached by the defendants. So that is my main prayer. So if that is not, it could not be found out by the report, then this is not a report at all, my lord. So that is why I filed an objection, my lord. And since my lord has observed on last occasion, my lord may even dispose of this petition, my lord, and setting aside the order and remanding back the matter for fresh consideration. That can be also done, my lord. Because the matter has been fixed for argument again on 4th of July.
No. The question is merely because the commissioner report is not favorable to you, you cannot claim that the sites of a rejected.
No, that is not my case, my lord. No, my lord, I'm not into that, my lord. Not favorable doesn't mean that I'm not even pleaded in this. I have my prayer, what is my prayer, my lord? In the suit, my lord. Kindly come to the suit, my lord. Kindly see, my lord. My whole prayer is based on.
You show me what was the direction issued to the commissioner?
Yes, my lord. That order, my lord, at page 62, my lord.
Page 62.
Yes, my lord. 11/4/23.
In which
This was
part
the
it is mentioned?
Yes, my lord. 65 relevant, my lord. Therefore, this court hereby appoints Mr. So-and-so for physical verification of the suit part and the land of the defendants. Has my lord got it? The defendants as well as the plaintiff, as per their land documents, he may obtain help from the circle officer, East Revenue Circle, Dibrugarh, and concerned lot mandal. The advocate commissioner shall take necessary steps at the suit At this suit is proceeding ex parte against defendant so and so, concerned lot mandal shall bring the cadastral map, Jabamandi and ledger book of drug number so and so to measure the land of Bishu Bauri and Bijan Bauri, Srimati so and so, as per their land documents. The concerned advocate commissioner is hereby directed to inspect the suit path along with the land of the aforesaid defendant as well as the plaintiff and get it measured by concerned lot mandal, and after such commission shall submit report accordingly. And pursuant to that, writ was also issued, page 67. And my whole prayer, my lord, in the pleadings, in the suit, my lord, kindly see, my lord, at page 24, my lord. This is the number one is the main prayer. I'm
Hey,
yes, my lord.
let notice go at this stage. Let the others.
Yeah, that yes, my lord.
Heard Mr. Chakraborty, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 30/5/2025 passed by the learned civil judge, Junior Division number 3, entitled suit number 51 of 2014. It is to be noted here that by the impugn order dated so and so, the learned civil judge, Junior Division number 3, Dibrugarh, has dismissed the petition number 22 of 2025, dated 15/5/2025, filed by the petitioner for rejection of the local commission report dated 25/4/2024, being vague for not ascertaining the facts about encroachment of the suit path on the day of inspection as per objective of order 29 rule 9 CPC. No, sorry, order 26 rule 9 CPC. Peruse the petition and the documents lesson record and also peruse the impugn order dated 30/5/2025. Let notice be issued to the respondent, returnable in 4 weeks, if be taken by registered post with ready and also by usual process within a week from today. And pending further consideration, the impugn order dated 30/5/2025, Hospital Learned Civil Judge Senior Division number 3, entitled suit number 51 of 2014, stands to state till returnable date.
All right.
List of 4 weeks.
Highly obliged.
Yes, Mr. Gogoi,
Lordship.
have you gone through the documents?
Lordship, I just now I have received a copy, Lordship.
Just?
Lordship.
Okay, let's second half then.
Lordship. Obliged.
7.
Seven. Okay.
Timing items 11 and 12.
I am against the concurrent findings of the concurrent findings. Sorry. Lord, I have
What is the substantial question of law?
page 6, my lord.
Page 6.
Page 6.
There is no other member, only one member in the
Yes, my lord.
tribunal.
In both the authority and the appellate authority, the single judge, my lord, which is required to by 3.
Where is the provision?
Yes, my lord. Order to section 21 of the act is
Okay.
section 21 of the act is, my lord, composition of authority.
Please.
This is authority, my lord. 21.
Real Estate Regulation and Development Act 2016.
Yes, my lord.
Section
21, my lord.
21.
This is the composition of the authority. The authority shall consist of a chairperson and not less than 2 full-time members to be appointed by the appropriate government. This is the authority, my lord, where the trial was conducted, my lord. And 43, my lord, establishment of real estate appellate tribunal. 43.3. Every bench of the appellate tribunal shall consist of at least 1 judicial member and 1 administrative member, 2 technical member, at least 2.
Section 40.
43, subsection 3, my lord.
Every bench.
Yes. And 45, composition of the appellate tribunal. Here, my lord, the appellate tribunal is also 1 member and the authority is also 1 member, my lord. Whether they have the jurisdiction under the purview of this act.
You show
Well,
me
this is-
the orders.
My lord,
Show me the orders.
trial court order is page 14, my lord.
Page
Page 14. This is order passed by 1 Gokul Mohan Hendik, acting chairperson cum member.
page number 14.
14, my lord. And the appellate order is page 8.
Yes, Mr. Sonu.
Lordship, this particular substantial question of law is not at all involved in this appeal because it is already decided by this honorable court as well as by the apex court, your lordship. That I may be allowed to refer a judgment. And another. And in the act itself, your lordship, it is there. Kind of paragraph 17 of my judgment, which I have.
Page number?
Paragraph 17, page 9.
17, page 9.
The third substantial questions of law so proposed was as to whether the order of RERA suffered if it is not passed in its full length, full strength, and amounts to violation of section 81 of the RERA Act 2016. The said aspect of the matter was duly taken note of the learned appellate authority relying on the judgment of the Supreme Court in Messrs. Newtech Promoters and Developers Private Limited, versus State of EP, reported in 2021 SCC online, page 1044. Have observed that the delegation had to hear complaints under section 31 of the RERA Act by a single member is permissible. The said aspect being already settled by the Supreme Court, the said substantial question of law so proposed cannot be said to be a substantial question of law involved in the instant appeal. And in the act itself, it is there, your lordship. And the Supreme Court judgment which was referred, this is Newtek promoter, long judgment, your lordship.
Which is the relevant paragraph?
Lordship, in the apex court judgment, apex court judgment, your lordship, relevant paragraphs are 105, 106, 103, page. Long judgment, your lordship.
What is the finding?
Lordship. It is page 27 it starts, lordship. 26, paragraph 100. Page 26, paragraph 100. Lordship got it? May I read you, lordship? Learned counsel further submits that section 21 of the act relates to the composition of the authority and does not deal with minimum bench strength. At the given time, the legislature has consciously avoided prescribing any minimum bench quorum strength to hear complaints by the authority. At the same time, the act only prescribes a bench quorum only of the appellate tribunal under section 43, subsection 3 of the act, and further submits that in the absence of the minimum bench quorum strength being fixed by statute, it is impermissible to treat the composition of the authority itself as a minimum bench strength. Learned counsel further submits that sections 29 and 81 are not in derogation to each other and operate in different fields. Section 29 is concerned with the meetings of the authority and does not envisage in its whole the substantial function, quasi-judicial functions, which the act cast upon the authority. The term meetings under section 29 does not deal with the performance of quasi-judicial functions which are referred to the authority under section 31. It can only refer to the meetings on policy, regulatory issues, and invited attention to sections 32 and 33 of the act, which are in the nature of policy regulatory decision of the authority is mandated under the act. It can further be noticed from section 29 subsection 3 and 4, which talks about questions before the authority to be disposed of within 60 days of receiving the applicant's application. And there is no reference to any complaints as indicated in section 31. Thereafter, lordship, it is 21 refers and 81, paragraph 81, lordship, last. The authority may, by general or special order in writing, delegate to any member of
Paragraph number 18.
81.
81. Okay.
Lordship, page 27, last bottom, lordship. The authority may, by general or special order in writing, delegate to any member, officer of the authority, or any other person subject to such conditions, if any, as may be specified in the order, such of its powers and functions under this act, except within bracket, except the power to make regulation under section 85 as it may deem necessary. Section 21 of the act relates to the composition of the authority, which consists of chairperson and not less than 2 whole-time members to be appointed by the appropriate government, but conspicuously it does not mention minimum bench strength. At the same time, concisely prescribes minimum bench quorum while constituting real estate appellate tribunal as reflected under section 43 subsection 3 of the act. The emphasis of the appellants was on section 29 of the act, which indicates the quorum of meetings of the authority. There is a specific provision that there shall be a meeting of the authority with the minimum quorum being prescribed. Such business of the meeting of the authority indeed would not be delegated to a single member of the authority in exercise of power under section 81 of the act. The term meeting under section 29 of the act does not deal with the performance of the authority in quasi-judicial matters, which are referred to under section 31 of the act. 31, Lordship, may I'll refer that after this, Lordship. 31 of the act. It only refers to meetings, policy, regulatory issues that the authority is mandated to discharge under the act. It may be noticed that sections 32 and 33 are in nature of policy, regulatory directions which the authority is mandated to be discharged indisputably have to be undertaken by the authority while functioning as a whole body under section 29 of the act. To add it further.
Okay.
Lordship. And now, Lordship,
Uh,
I would like to refer
So
section.
in view of the decision of this court, coordinate bench of this court in
Lordship.
Area Appeal number
Appeal
of
number
2024.
20 of 24.
So this substantial question cannot be framed.
Lordship.
2 of
2024.
And section 30, Lordship itself in the act, vacancies, etc., not to invalidate proceeding of authority. It is there itself. Section 30 of the act. No act or proceeding of the authority shall be invalid merely by reason of any vacancy in or any defect in the constitution of the authority or any defect in the appointment of a person acting as a member of the authority or any irregularity in the procedure of the authority not affecting the merits of the case. It is section 30 for the RERA. And then, Lordship,
So,
55.
here only one substantial question we may perhaps frame. That is one.
One, no perversity, Lordship. It is admitted from the whole record if your Lordship go through. Lordship.
Well, regarding the framing of substantial question of law, so one may be formed and will satisfy the court in the later course of hearing, madam. Will satisfy it. But I have to go through it on what subject matter it was passed by the apex court as well as the coordinate bench of this court, madam. Well, at this moment, madam, the appeal may be admitted for hearing first. Then we will satisfy the court. If the court is, we fail to satisfy the court, this is it, madam. At least.
No, if the appellate tribunal can pass the judgment sitting singly, where is the question for framing substantial?
Similar situation was rather in Pondicherry, Punjab and Haryana High Court, my lord. It was passed in 2020. In that case, my lord, in the authority was also, judgment of the authority was also passed by a single member and the appellate court was also passed by a single member. In that case, the division bench of the Haryana, Punjab and Haryana High Court set aside all the authority.
But the Supreme Court decision is there.
Yes, my lord. I have to go through it, my lord. So we will hear the matter.
No, before
What my
hearing the
learned
matter-
finish, what my learned finish submit, my lord. It is submission of a lawyer. So we'll go through it, my lord. I have not gone through it, my lord. And the judgment of this our coordinate bench also, my lord, can you see what is the actual matter, my lord.
No.
So it was a very latest judgment, 2024.
No, unless we admit the matter, how can we list it for hearing?
Lordship may kindly admit this matter with a single question of the first substantial question of law. That can be.
Anyway, he has been challenging it that there is no perversity.
So at the time of hearing, it will come out, my lord. He will get a chance, I will get a chance, my lord. If I fail to satisfy the court, my lord, court will dismiss my bill. He will again. That is my submission before your lordship now. Without hearing how.
No, you first show me how it is contrary to the provision of the Real Estate Regulation and Development Act 2016.
My lord, for admission, some time may be given, my lord. I will go through it, my lord, and on next day I will satisfy the court.
Again,
my lord. On the admission hearing, my lord.
okay, all right. Mr. P.K. Das, learned counsel for the appellant, and also heard Mr. Yesung, learned counsel for the respondent.
His Lordship, since
Mr. Das,
2015, Lordship. Since 2015, the respondents is suffering, Lordship, huge money, and they have admitted, Lordship, in the WS, and they have proposed a proposal before the tribunal.
First, let him go to the judgment,
Lordship,
which you have relied upon.
Lordship.
Mr. Das, learned counsel for the appellant, as for listing the matter, we'll fix it that.
Lordship.
July. On the point of
Can it be, Lordship, immediately
substantial on the framing of substantial question of law?
Can
Where is accordingly allowed, list the matter on.
Can it be on 28, my lord?
Can it 20?
Okay.
28.
20?
28.
Can it be immediately after opening? Lordship?
Twenty-eight.
28, Lordship.
36.
May it please the Lordship. Lordship, the appellant as a third party filed registered the execution proceeding, Lordship, under Order 21 Rule 97. During that pendency of the application, the executing court kept in abeyance the execution proceeding. Then it was dismissed. Against that, we have filed a statutory appeal under Order 21 Rule 103. And Lordship, along with the delay condonation petition for 20 days, along with the stay application. That delay condonation application has been rejected, Lordship, at page 67.
What is the ground you have taken there?
My Lordship, ground is a delay is only 20 days. Now this is a discretionary power, Lordship, but while appreciating the pleaded fact, because
No, that's all right. Discretionary power has to be exercised in accordance with law.
yes, now that is my case, Lordship, that discretionary power while exercising, if learned court below misread the pleaded case, Lordship.
Page number?
If Lordship come to page 71.
71.
Page 71, 10th line from the bottom, Lordship. Line from the bottom, and it starts from in the instant case. Lordship, in the instant case, it appears from the impugn order to 7025 passed by the learned executing court in title execution number so and so. Also the memo of second appeal and other documents filed by the petitioner that the mother of the present petitioner, late Nazima Nessa, had filed title suit number 11/2008 along with other plaintiffs against the Sirajul Islam so and so so and so. Now here, Lordship, learned court below perused all these documents. Now this finding, Lordship, this Nazima Nessa, she was the original owner of the land. It is admitted fact. And she did not file any case. And here it says mother of the present petitioner. Petitioner number 1 to 3, Lordship, They are the sons of one of the daughter of Nazima Nesa. And the petitioner number 4, she is the daughter of Nazima Nesa. So, and Lordship, this Nazima Nesa, she did not file any suit. The sons, this Nazima Nesa had 2 sons and 2 daughters. Two daughter and 1 son filed this case against this 1 son and this decree holders and others, Lordship. And again, Lordship.
You tell me where the delay has been explained. We are only concerned with the
Yes,
delay.
yes, Lordship, delay, Lordship. That, Lordship, I have narrated this, Lordship, cases at page 61, Lordship.
Hmm.
61, 6 is twice, Lordship, basic. That the petitioner number 4, being one of the daughters of late Nazima Nesa, being acquainted with the facts of the case and taking steps for herself and on behalf of the other petitioners who are legal heirs of late Samsur Nahar Begum, one of the daughter of late Nazima Nesa. The petitioner number 4 alone in this is in direct contact with the counsel representing the petitioner before the executing court regarding the instant case, and other petitioners are cooperating the petitioner number 4 as and when required. That after passing of the impugn order dated 7/3/25, the petitioner number 4 obtained the certified copy on 24/3/25. As the same was not uploaded in the website till 17/3/25, the counsel for the petitioners advised her to challenge the said order before the appropriate court. However, the petitioner number 4 could not visit the chamber of their counsel due to various ailments. The petitioner number 4 is a patient of asthma and severe respiratory disorders along with arthritis, as a result of which she is unable to move freely and remain under constant medical treatment. In the month of March 2025, she was hospitalized due to respiratory disorder. Further, the petitioners are also suffering financial constraint due to happening of certain unavoidable circumstances in their family. The petitioner number 4 could able to visit the chamber of their counsel on 30/4/25, and after going through the certified copy of the order and other materials document, the petitioner number 4 was advised to prefer an appeal along with an application for condonation of delay, as well as an application for stay. Thereafter, the counsel also took some time to go through the brief of the case and preparing the case for filing before the court. Accordingly, the connected appeal is filed on 5/5/25 along with application of stay and instant application for condonation of delay. Then we explain the date and all at para 9, Lordship. Then we have
when the order was passed,
Lordship.
7/3.
The-
7/3. Order was passed on 7/3.
Yes, that impugn order of the executing court, Lordship. Now, Lordship, or delay is only 20 days.
And certified copy, you have obtained certified copy on 24/3/2025.
24/3/25, Lordship. As that order of 7/3/25, it was uploaded on 17/3/25. Then only we could know that our case is rejected, Lordship. And all along, Lordship, the petitioner number 5, there are history of litigation, Lordship.
No, do you have any documentary proof to show that the order was uploaded on 17/3/2025?
That was not there, Lordship.
Then how can we believe it?
Lordship. Actually, only my learned friend says that screenshot was there, but it is not here, Lordship. But my submission is, Lordship, only 20 days is delay, Lordship. And on that day, when we filed,
Maybe,
Lordship,
maybe 20 days or 20 years, but you have to explain.
that explanation I have given, Lordship. And Lordship kindly see, the date of the trial executing court has been fixed on 15/7/25. It is not today, it's coming July 15th, Lordship. Now my case, Lordship, this is a technical approach has been taken because it is a statutory appeal, Lordship. Now, by this time, had this petition has been allowed, by this time, Lordship, that appeal could have been decided either way, Lordship, before the date fixed before the executing court. So that hyper technical approach, Lordship, that deprived me of a statutory right. My case is that let the appeal may be heard because it is a statutory appeal. Statute provide whatever way it goes. This is a different thing, Lordship. But that, Lordship, would not have been deprived. And Lordship, the appreciation of this, if Lordship sees the impugn order, other paragraph also, Lordship. It's at page 71. I have shown, Lordship. At page 72 also that miscase, that execution here, it says Sirajul Islam and others. Only the Sirajul Islam is the judgment debtor, one of the son of this Nazimun Nisa. Here it says others. Then again, Lordship, in paragraph 10 also, the learned trial court said, but without going through the merit of the appeal and maintainability of this, one of the petitioner's point emerges here that the appellant's petitioner herein are not one, but 4 persons who claim their title over the suit property through their mother.
Okay, Mr. Decker, let us confine to the explanation forthcoming for the delay only. What are the medical documents to show that in the month of March you have been hospitalized due to respiratory disorder?
That one certificate is given, Lordship. That is discussed, Lordship, in the impugned order.
Where is that document?
That document, Lordship, in the miscase, Lordship, we have
not enclosed.
Miscase we have annexed, Lordship, this stay petition, Lordship. Page 88, Lordship. This document to only show that she was suffering from illness. It will not cover this entire thing, Lordship, period. Page 88 of that miscase, Lordship, Annexer A. She was hospitalized on 12 and released on 13, Lordship. This document only to show, Lordship, that she is suffering from illness. This document will not cover, Lordship, entire thing, Lordship. But Lordship, here, Lordship, that
can it be said that you have sufficiently explained the delay?
Lordship, my respectful submission, this delay of 20 days, and there is no finding of any mala fide, Lordship, or any we have not approached the court bona fide. There is negligence or mala fide intention because running late, we are taking under the risk, Lordship. But otherwise, Lordship, they also did not file any objection in this case. But Lordship, my thing is that only 20 days delay. This is in my respectful submission, though not day-to-day delay is explained, Lordship, but it is a sufficient explanation is there, Lordship. And this perversity I'm urging as a ground because all these facts, Lordship, here it says that petitioners are mother of the petitioner's mother is Nazimun Nisa. Where is the petitioner number 1, 2, 3? They are grandson. And it is very much clear in our delay condonation application who is who, Lordship. It is very much explained.
Okay, all right.
And secondly,
yes, Mr. Yeah.
May I please, Lordship? Lordship, before advancing my argument, Lordship, I want to rely upon the observation made by this honorable court in the latest order of your Lordships. That is at page Annexer 7, page 80, and relevant para, your Lordship, at page 87, paragraph number 15. It is made on the observation of the Honorable Apex Court of 1966. What it has been observed by the Honorable Apex Court. Notably, in the case of Melaram so-and-so, the Honorable Lordship got it. A court held that an appeal presented out of time is an appeal and an order dismissing it as a time bar is one passed
in an appeal. And in the case of Sudam Singh so and so, one of the questions that arose was whether the dismissal of an appeal from a decree on the ground that the appeal was barred by limitation was a decision of an appeal in the appeal. Then it was held as under. We are therefore of the opinion that where a decision is given on a merits by a trial court and the matter is taken in appeal and the appeal is dismissed on some preliminary ground like limitation or default or imprinting, it must be held that such dismissal, when it confirms the decision of the trial court and on merits itself amount to an appeal being heard and finally decided on the merits, whatever may be the ground for dismissal of the appeal. So here, your lordship, so far this present second appeal is concerned, they have proposed two substantial questions only on the ground of limitation regarding perversity. That substantial question of law, your lordship, as proposed lordship at page 13 of the memo of appeal. Whether the exercise of discretionary power by the appellate court in a hyper-technical manner, perversely and ignoring the settled principle of law, is not condemning the delay of 20 days by be permitted in law to take away the appellant's statutory right of appeal under Order 21, Rule 103. Whether the learned appellate court committed perversity in not appreciating the pleaded facts constituting sufficient cause for condoning the delay of preferring the appeal and materials placed on record while arriving at pandemic findings. These two substantial questions of law has been proposed. So my submission before this honorable court, so far the trial court judgment order is concerned. What is that order? Lordship, what happened? As read out my learned brother from the impugn order, it reveals there was a suit. That is a title suit of 11 of 2008. That title suit was for declaration of right title interest, for partition, and for cancellation of a sale deed. What was the sale deed? That is sale deed executed by the defendant number 1 in that suit. Who was the defendant number 1? Defendant number 1 is the brother of the present petitioner number 4. That defendant 1, he sold out the land by a registered sale deed in favor of the present predecessor of the present respondent by registered sale deed. And immediately after execution of the sale deed, he did not hand over possession. Rather, he entered an agreement with the predecessor of the present respondent, that is a tenancy agreement. But subsequently, he did not deliver possession. In the meanwhile, that suit was instituted by the present predecessor of the petitioner number 4 and the predecessor of petitioner number 1 to 3, claiming declaration of right title and interest, partition, recovery of possession, and for injunction, cancellation of my sale deed. That suit was dismissed, holding that these petitioners, who are the plaintiffs, they have no right title and interest over the suit. Against that, appeal was preferred, challenging the trial court judgment. That was also dismissed. And against that, a second appeal has been preferred. And this is pending before this honorable court. Because there was a delay in filing the second appeal, still that is not admitted. That is the position so far the right title and interest is concerned. In the meanwhile, what happened? In the year 2008 itself, the predecessor of the present respondent, on the basis of that tenancy agreement, filed a suit for ejectment of the defendant number 1, that he is to be evicted. That suit, though it was dismissed earlier, in an appellate court, that was decreed. Against that decree of ejectment, the said defendant number 1, who is the brother of the petitioner, they preferred a revision before this honorable court, challenging the decree passed by the appellate court, ejecting the defendant number 1. that was dismissed. That was dismissed. Therefore, what they have done, immediately, this respondent number that, the brother of that, the defendant number 1, filed a section 47 petition, questioning the executability decree. In the meanwhile, these petitioners also filed an application under Order 21, Rule 97, sorry, 99, 98, 99, 101, claiming right title and interest. Because under Order 21, 103, 101, right of the parties to be determined, independent right over the suit property. So that petition was rejected by the learned trial court. Now I am coming to Annexure 3, Lordship.
Page number.
Page number, Lordship, 37.
Yes.
Lordship, this is the trial court, executing court judgment orders on Order 21, so and so. At page 40, Your Lordship. Firstly, they contended that the executing court lacks of jurisdiction to enter. Lordship got it. Firstly, they contended that the executing court lacks jurisdiction to entertain the issue raised by the petitioners. They assert that the applicants, in collusion with the judgment debtor, have filed this application to delay the execution process, even though the judgment debtor has already exhausted legal remedies up to the Honorable High Court. Secondly, the decree holders claim that the applicants have no ownership or possession over the digital property and mere third parties with no locus standi in the execution proceeding. They contended that the application is barred by res judicata, as the applicant's predecessor had previously filed title suit number 11 of 2008, which was dismissed on 12/10/2015. The subsequent title appeal number 9 of 2016 was also dismissed on 29/8/2019, and on second appeal was filed until 2023. Thus, the findings regarding ownership have attained finality, barring the applicants from re-agitating the issue before the executing court. Further, the decree holder asserts so and so. This was basically our submission, and ultimately, Your Lordship, the learned trial court at page 42. It is further taken into Lordship got it. It is further taken to note that the applicant's predecessors had earlier filed title suit 11 of 2008, which was dismissed by the court by judgment and decree dated 12/10/2015. The subsequent title appeal number 9 of 2006 was also dismissed by the learned appellate court on 29/8/2019, thereby affirming the findings of the court. As no second appeal was filed within the prescribed period, the findings regarding ownership, title, and possession have attained finality. Thus, the present application is barred by res judicata as enunciated under section 11 of the CPC. So, under that circumstances, these applications are rejected. This is arrived at finality. What substantive question of law has been formulated, supposed to propose here? No. Because as held by the Honorable Apex Court, that, as I have already read it out, 1967, that we are therefore opinion that where there is a decision is given on merit by the trial court and the matter is taken in appeal and the appeal is dismissed on some preliminary ground like limitation or default in pleading, it must be held that such dismissal, when it confirms the decision of the trial court on the merits, itself amount to the appeal being heard and finally decided on merit. So here, the substantial question to be proposed on that appellate trial court judgment. Now here, only substantial question of law has been proposed on the question of limitation, on the perversity. It's a question of fact.
No, the question of limitation is a mixed question of
law and fact.
Law and
Lordship, definitely a question of law and facts. Even then, that arrived at finality, that the trial court judgment regarding res judicata, they cannot deny because they have not submitted
No,
here.
no. That has to be considered if the appeal is admitted there.
Lordship, No, so but before this honorable court.
In this RSA, we are only concerned with whether the learned court is justified in dismissing the petition under section 5 of the limitation. Act.
Even then, your lordship, the substantial question of law that the judgment passed by the order passed on view of the order of limitation, on the point of limitation, on the application of limitation was rejected. So that judgment has confirmed, it was confirmed. If it is confirmed as held by the Honorable Apex Court, the substantial question of law proposed is not only basically on the question of limitation, because it has been affirmed. When it is affirmed the trial court judgment, definitely both the court's judgment to be, whether it is illegal, that is to be agitated before your lordship, Honorable Court. Because as and when limitation petition is disposed of, the trial court judgment has been
Affirmed.
Then second level has been deferred. Then the substantial court to be proposed or to be formulated on the basis of both the judgment, not only the limitation point.
No, the question is, Mr. Punya,
Lordship.
that appeal, that matter has not been heard on merit.
Lordship, that is admit. I am admitting it. There is not hard on merit. Why it is not hard on merit? Because the reasons shown, and I'm coming to it. Paragraph number 10 at page 73. There is the impugn order. But without going through the merit of the appeal or the maintainability of it, one pertinent point emerges here that the appellant's petitioner hearing are not one, but 4 persons are claimed their title over the suit property, though their mother late Nazimun Nessa. Through their admittedly, the petitioner received the certified copy of the impugn order on 24/3/2025. The medical document submitted by the petitioner Nurna Begum shows that she was admitted on 12/3 and discharged on 13/3/2005. Petitioner Nurna Begum stated to be 70 years old and she is the sister of all other 3 persons. It definitely is not the sister typographical error. She is the younger sister of their mother. Of petitioner number 1 to 3. There is no sufficient reasons shown by the petitioners as to what happened, what prevented the other petitioners. Definitely, there in their application, they have stated they have not taken any steps. The application filed by them, that the petitioner order 21 application was filed by them before the learned trial court, that the present memo of appeal was signed by them before the Honorable Learned Appellate Court. These are the persons, all they have signed it. Who prevented? Lordship, this is a matter since 2008. These are dragging. Why I am arguing before this Honorable Court? Because very intention. Because Naya claim in the memo of appeal, they have taken a ground, your Lordship. Z, page 11. For that, as in the impugn order, Lordship got it. For that, as in the impugn order, there is no finding that the appellants were unscrupulous litigation and they did not pursue the remedy bona fide under Order 21, Rule 97, 101 and 103 CPC, or they adopted dilatory tactics. No findings is required, your Lordship. From the record it reveals, all the documents they have submitted before the Learned Appellate Court, they have not submitted before this Honorable Court, because they know it. They have challenged this cell deed in the year 2008. Suit has been dismissed. When he was cross-examined, so it comes to the record. These petitioners, when they were cross-examined before the trial court, they have stated property was partitioned in the year 1983 by the brothers. And the brothers against whom they filed the suit, who executed sale deed against me, He has stated before the trial court in our suit, no, I have conducted the case. I have engaged the advocate on behalf of my sisters. What is going on? What is going on, Your Lordship? This is the tactics and nothing else. Decree has been passed, appeal has been preferred, appeal dismissed, against second appeal has been preferred, in spite of their having the decree, whether there any option to file an application under Order 21, Rule 99, claiming independent right to decide the question of right title interest. And by taking advantage of that plea, of that application, now this proceeding is going on. Second appeal, second time of second appeal has been preferred before this honorable court. Is it not to be considered by this honorable? This is the. Now my submission before this honorable court, this substantial question of law as they have proposed is not a substantial question of law. It is my humble submission before Lordship.
Okay. Lordship, my learned friend's first contention, Lordship, please come to Lordship order itself, Lordship. Page 88. Paragraph 18.1. Paragraph 18.1, 1, 2, 3, 4, 5, 6 line, Lordship. In the case of Sandeep Prasad and others, it was held that when an appeal is dismissed on the ground of delay in filing the same is not condoned, the doctrine of merger shall not apply. So my learned friend is saying that it mars that trial court. So this is answer is lying in this. And secondly, Lordship, my learned friend entered into the facts of the case, but he did not present the whole case. Only one thing I'll like to say, because that Sirajul Islam and their client, they are in collusion, Lordship. Why I'm saying so? When the decree holder came to our land with the sale deed, then we filed a title suit number 11 of 08. Two daughters and one son against the Sirajul, who is judgment debtor, also the decree holder Lazima, and the power of attorney. It was sold by a power of attorney. Now, dear Lordship, we filed this case on 5/1/2008, that first case, where the decree holder is a party in there. Then they filed a joint written statement, and in the joint written statement, it was filed on 17/4/08. They admitted that Nazimun Nessa is the original owner. And it is also admitted that the said land is mutated in the name of Nuzrul and Sirajul. That is one of the plaintiff and the defendant number 1. They admitted in the written statement. But Lordship, later on, the instant title suit to 200/208 filed on 17/6/08 only by the decree order against only Sirajul. They admitted in earlier case, written statement, that Nazrul and Sirajul has mutated the land of the Nazimun Nessa. And while the decree holder is claiming, filing the state, only the Sirajul Islam made party. And Sirajul Islam also did not took the point of non-gender of necessary parties. Now land is 3 kotha 7 lesa. The land is sold by the distinct more than half, 2 kotha some lesa, Lordship. And there is no partition, Lordship. So again, it is the Sirajul, the judgment debtor, he is against us. He did not contest that this title suit raising that issue. Then look here, it is non-gender of parties. That is not there. Now we are not bound by this decree. That is why, Lordship, this 101 says the determination of right title interest. It is the determination. Now what my learned friend is saying that we have filed this suit. Yes. Now it is pending before the subjudice before the High Court. And the in the impugn order also, it is said that both sides admitted that second appeal is preferred by the petitioner against the judgment and order that the title appeal number so and so and so and so. So now this our second appeal is pending before the court, and appeal is a continuation of the suit. So Lordship, this 104 order 21, it will apply. And there cannot be a res judicata as held by the court below, because order 21 is a complete code. Here, Lordship, if Lordship sees the 104, order under Rule 101, 101 is question to be determined. All question, including question relating to right title interest of the property against between. So then 104 says order under 101 and 103 to be subject to the result of the pending suit. Every order made under 101 and 103 shall be subject to the result of any suit that may be pending on the date of commencement of the proceeding in which such order is made, if in such suit the party against whom the order under 101 and 103 made has sought to establish a right which. So, Lordship, on the day of, well, we are filing the 97 application, on that the second appeal is pending, Lordship, sub judice before this court. Now, this determination of this second appeal, it will hold good against the determination of under this 101. And if Lordship goes through this document, my learned says that I have not filed all the documents because they are vernacular or also the huge document. I have properly craved leave of this court. If Lordship sees the judgment of the trial court and this thing, the title was, our title was rejected on the basis of mutation of these two brothers. Mutation can, because it is a by way of inheritance, Lordship.
No, Mr. Dekka, we
Lordship.
are not concerned with all those.
Yes, that will be determined by the appellate court if Lordship allows my this thing, Lordship. Otherwise, because and that says that
And at what is this? And now the case is pending there.
in the executing court, Lordship, executing court, it is fixed for report, Lordship, on 15/7/25, Lordship. They have applied for this, Salan is also given. So it is a last stage, Lordship. So far as this appeal is concerned, Lordship, it would have been heard before that date also by the appellate, lower appellate court. And we have stated in our stay petition before this court that it can be heard. We are not on the delay point, Lordship. And this judgment of this Supreme Court also says that this. I'm just handing over the judgment, few judgments, Lordship. Here, Lordship, paragraph 1 of 1998, 4 SCC 543, Lordship. I'm giving it, Lordship. Paragraph 1, it says, I'm just reading 3 lines. Even after one reaches the stage of final decree, he has to undergo a long distance by passing through the ordinance procedure in the execution proceeding before receive the bowl of justice. And here it says that it cannot be. It says that in the sort of aforesaid statutory provision of 21 lays down a complete code for resolving all dispute pertaining to the execution of the decree for possession obtaining by a decree holder, and those attempts at executing said decree meet the rough order. Once resistance is offered by a purported stranger to the decree, and which comes to be noted by the executing court as well as by the decree holder, the remedy available to the decree holder against such an obstructionist is only under Order 21, Rule 97, Sub-Rule 1, and he cannot bypass such obstructions and insist on reissuing of warrant of possession under Order 21, Rule 35 with police help force, as that course would amount to bypassing the circumventing the procedure laid down under Order 21, Rule 97. We direct the executing court to consider.
Mr. Dekka, okay, you furnish the judgment.
I'll furnish it, Lordship. These few judgments I have this thing. My only contention is that statute has provided us certain remedies, Lordship. We are availing those remedies. In availing those remedies, Lordship, we have not done anything wrong. This statute provides, Lordship. And that even that executing court also did not determine. He says res judicata. When Rule 104 says that it is subject to the appeal, Lordship. So that our arguable point before the appellate court on merit, my Lordship.
We will see. Okay, we will pass the order.
Lordship, I'll giving the handing over the certain decisions. Obliged, Lordship.
Mr. Bhuya,
Lordship.
let the matter be heard finally there.
Even any death can be fixed by Lordship after formulating the substantial question of Lordship.
As you will.
Only protection may be given because of this, Lordship.
He's not in possession. Possession is other person, his brother.
I'm giving the judgment on that owner, my lord. Owner.
Brother. For whom they are litigating, whom they are fighting.
that the defendant who sold it out to let,
If
he
I'm-
is in possession of that property.
If I'm in London, my possession need not be a physical possession, Lordship.
No, maybe. Let us do one thing. We will formulate one substantial question of law and we will dispose of the matter here today.
Lordship. Lordship, then the direction will be given to dispose of the appeal within some-
Yes,
fixing the date, Lordship.
we will fix a date
Lordship.
and now we will also fix the time.
Lordship.
within which the matter may be.
Lordship. Lordship. And even the
So their services have been regularized in the year 2000.
In the year 2017, Your Lordship, there 17, there is
And
a
the DA claim is from 2019.
Lordship. In fact, what has happened, Your Lordship, 2017, there is a decision that the present petitioners, Your Lordship, members of the petitioner association will get the same pay and allowances as that's a cabinet decision, Your Lordship, like the present petitioner, like the regular teachers, Your Lordship. Your Lordship will get it at page 25, Your Lordship. Now, after that, Your Lordship, what they did, Your Lordship, while Your Lordship paying this, Your Lordship, DA, Your Lordship, to other employees, Your Lordship, we were not paid at equal amount, Your Lordship. That's the case, Your Lordship. Your Lordship will kindly come to page 33 of my petition. Your Lordship will find that while there is an increase so far as the enhancement of DA, Your Lordship's for others from a particular date by around 17%, we have not been paid to that extent, Your Lordship. We have been paid, Your Lordship, from 10% from 1st September 2022 and 7% from 1st April 2023. And then, Your Lordship, rest, Your Lordship, from not then onward.
Once your service has been regularized, where is the question for denying the benefit to you?
No, but their service has not
Not,
been regularized.
the service has not been regularized.
They have been given the benefit of
Regular time scale, Your Lordship.
Regular time is.
Time scale along with other allowances.
How can you discriminate them?
well, they are still
No, they have been given the regular scale of pay.
regular scale of pay was given to them, but they are still contractual employment.
Even then, by giving regular pay scale, you are not giving the benefit of BA. What is this?
Very specific, their decision, your lordship. Same benefit as regular teachers, your lordship. Page 25, your lordship.
Subsequently, they have been regularized. Now they have been regularized, my lord.
Regular.
They have been regularized with the initial.
With effect from?
With effect from, my lord, 2007. With effect from 2007.
No, that's your lordship. A section of them has been
Yes, ma'am.
regularized, not all.
We have issued an advertisement for regularization of their service, my lord. Some of them have accepted that, my lord, with the initial scale of pay, my lord. So now
They are getting, your lordship, they are out, your lordship. Now, these members of these associations, they are still contractual. Page 25, your lordship will get, your lordship, their decision. In inviting reference to the above, I am directed to state that from the beginning, it was decided that the contractual LP, UP teachers under SSA will get same benefit of regular teacher under the Directorate of Elementary Education. Now, once they say that we will get the same benefit, and thereafter we are getting the regular time scale of pay, your lordship. Now, while paying the DNN allowance, they have discriminated, your lordship. That is why we are before this honorable court, your lordship. They all along submitted that they are processing the matter in a positive manner, your lordship. And therefore, your lordship, they are also not filing their affidavit in opposition. They say that since it is going on, and we have also accepted that, your lordship. Now, since it is pending, your lordship may give them some time, your lordship. In the meantime, your lordship may only direct them by giving a specific time, your lordship, that they should produce the order before this honorable court. Either way, your lordship. Either our favor or against, that's a different matter, your lordship. But at least they should come to a certain conclusion, your lordship. That's what we are praying before this honorable court, your lordship. Let a direction be issued, your lordship, keeping the matter pending, that this will bring it to a logical conclusion, your lordship. Now it has moved from, your lordship, directorate to secretariat, then finance, then.
The problem is that Mr. Khatuniar,
Yes.
this order was passed by this court on 23rd of May 2025.
Yes, ma'am. This
And
communication.
before fixing of the next date, the letter was written by the secretary,
It was 21/6.
21/6.
That
So
is why
for what happened in between? Either you have not communicated them this order, or they are skipping over the same.
No, my lord, in fact, in this communication also, they have mentioned the matter is next scheduled to be listed on 12. As per High Court Order 23/5/2020. Third line from bottom right, third paragraph from bottom.
We are in June, your lordship, now.
And Mr. Khatuniar, you see this page number 25.
Yes, ma'am.
It is categorically stated the contractual LP, UP teachers under SSA will get same benefit of regular teachers under the Directorate of Elementary Education, Assam.
Yes, ma'am.
So if you are taking any stand contrary to this, it is against your own order.
So we are not, right now, we are not taking any stand, my lord.
No, the matter, the way the matter is being taken up by the respondent authority, it appears that they are not going to implement their own order.
Now, when the government has sought for some opinion from the learned advocate. This is why I'm praying for some time so that.
And what is the opinion of the finance department?
In fact, kindly, my lord, come to next page, my lord. Second page of the communication. Second paragraph. In this regard, finance department has informed that they only issue the OM enhancing DNS allowances, DNS relief in respect of regular government employees. It is up to the administrative department, that is the Department of School Education, to examine the matter and see whether the petitioners are entitled to draw enhanced DA or not, and take action accordingly.
Then why the school education department has not taken the decision?
That is why, my lord, we are taking, my lord, we are taking the decision, my lord. Now.
No, referring the matter to Advocate General.
Maybe, my lord.
Well, this OM at page number 25 is very much clear.
In fact, if department has some dilemma, they can obviously obtain opinion from the learned advocate general, my lord. Being a law officer of the state, my lord.
No, that's all right.
My lord, they have sought some opinion, my lord.
While the order was passed on 23rd of May 2025, till this 21/6/2025, no step was
They
taken.
almost took 1 month to communicate.
Hmm. So if you take a 1 month time to communicate the letter to the Advocate General, then we don't think that within another 1 year you will be able to take any decision on this point. In the meantime, some of them might be retiring also.
If it is decided in favor of the petitioner, obviously they will get money. After retirement also they will get money.
Have you seen the news on the other day? How many contempt cases are pending against the secondary education department? No. It is the national news. Anyway, Mr. Botakor, let it be after vacation. We'll see what action they will take in the meantime.
If your lordship can, your lordship direct them to at least place by
The
that.
problem is that matter is pending before matter is pending before the office of the Advocate General.
Lords.
So let us wait for some
Lords.
time.
Lords.
Heard Mr. Portakur, learned counsel for the petitioner, and also heard Mr. Khatonier, learned standing counsel for the secondary elementary education department. Mr. Khatonier, learned counsel for the learned standing counsel for the elementary education department. Producing a letter of the secretary to the Government of Assam Department of School Education addressed to the Advocate General Assam. Submits that the department has written a letter to the Advocate General seeking his opinion on the matter. Especially whether there is any legal obligation on the part of the government to accede to the demand for payment of DA as made by the petitioner based on ROP rules and notification that have been issued. Then Mr. Khatunier further submits that the matter may be listed immediately after reopening of the vacation. There is accordingly allowed, rest shall list the matter on fixed 23rd July. 23rd of July.
Lords.
After that, madam.
The letter produced before the court today shall be part of the report.
Can it-
mark and be marked yes. And annexer white.
May be taken up in the first week of August, my lord. First week of on 5th or 6th.
6th.
6th, my lord.
Timing item 16.
May it please your lordship. Lordship, my learned senior is busy in another court, your lordship. Kindly make it for time being, your lordship. Lordship allows. After some time, your lordship.
Who is your senior?
He's in court number 11, your lordship.
Pardon?
He is in court number 11, your lordship. He's
Who is your senior?
R. Sharma, your lordship. Deeply obliged, your lordship.
Timing item 17.
My lord, this additional affidavit in record, my lord. My junior flag mark it, my lord.
Oh, why this affidavit is being filed?
My lord, in our condonation petition, we have taken that this petitioner is the, my lord, poor person below poverty line, my lord. And they have also, my lord, annexed the documents, my lord. And lordship also, Paul, my lord, in record lordship, it is also available, my lord, as per my lord, this petition file before the trial post, my lord. So, my lord, this honorable court also, my lord, well, liberty to file additional affidavit regarding, my lord, whether they are the poor or not. So admittedly, this my lord Sahajan Ali, who is dealing with the case, my lord, he is a poor person, my lord. And my lord, I have gone through the record also, my lord. The counterclaim which was filed before the learned trial court, my lord, in the year 2018, there also a, my lord, paragraph regarding his, my lord, this person is a poor, my lord. And he used to go Kerala and Andhra Pradesh, my lord, for his livelihood. So sufficient reason has been assigned before the trial court, appellate court, my lord. First appellate court.
So delay was for how many days?
My lord, this is 1 year, 7 months, 15 days. So let it be hard on merit, my lord, because the property in question is, my lord, it is between the, my lord, amongst the brothers, my lord, own brothers, my lord. And this defendant are in possession, my lord. And the initial, my lord, the title suit was for a specific performance of a contract. So, my lord, disputed question of fact is before the, my lord, trial court, my lord. And that is not decided, my lord. Lordship, can you see page, my lord, 59? The objection, petition which was filed before the, my lord, first appellate court. And they have taken the ground of that property.
What is your submission?
First of all, madam, I have not received a copy of this additional affidavit, madam, which they have filed, madam. The next thing is that, madam, today was fixed only for the IA. So, my lord, my only submission is that, madam, let this matter come up for order 41 hearing, madam, because the appeal is yet to be admitted, madam. So, there, my lord, lordship will hear both the sides and see whether, my lord, there are substantial questions of law or not, madam. So, one opportunity may be given because today it came only for orders for hearing of the IA.
You have not furnished your additional affidavit to him?
My lord, at that time, no, notice was not issued, my lord. This was directed to somewhere. That point of time, notice was not issued in this case. But along with the notice, it should have come. Lordship may fix it on 14th, my lord, on the reopening date, my lord. Execution case is going on, that's why some.
When the next date is fixed?
15, my lord, it was 15/7.
15/7.
Yes, sir.
So we'll fix it on 14.
Yes, 14.
Heard Mr. Ziyuddin, learned counsel for the appellant, and as thus learned counsel for the respondent. As agreed by learned advocates of both the parties, this is a legislative matter on 15. In the meantime, Mr. Within, learned counsel for the appellant shall file a copy of the additional affidavit to Mr. Das during the course of the day.
It may come under the order 41-11.
Yes, sir, it's the matter under column. The column under order 41 rule. Item 34.
Lords. Lordship, in within a short period, Lordship, what I am understand is in this petition, Lordship. This petitioner is a third party. He is not involved in the suit and miscase, Lordship. He is a third party. And order, the impugned order, Lordship, page number 75. I think there is no any wrong finding in this order, as because of suit was pending before this concerned court. And page number 76 clearly stated, however, such an order does not cause prejudice to the plaintiff since the matter remains sub judice before this court. Whenever suit was decided, then party who, as per the law, will be benefited. But in this time, this matter may not be interfered by this honorable court, Lordship, because of this petitioner is a third party.
My lord, may kindly come to the next page, page number 77, my lord. That is my petition by the third party. Paragraph number 2. The plaintiff as well as the defendants, my lord, they are fighting for this plot of land. Dark number 498 under patta number 180, Khatian number so of Moza Suprakandi. And paragraph number 1, that is my plot of land, my lord. Dark number 293, patta number 288. That is not the subject matter of the suit, my lord. It will not cause prejudice to the plaintiff, but it is causing prejudice to me because I am not able to get the compensation amount, my lord. This aspect has not at all been considered by the learned trial court. Both the lands are completely different plots of land, different Moza, my lord, different dark number, different patta number. Khatian number is also completely different, my lord. So it will not cause prejudice to the plaintiff. That is okay, my lord. Moza is, my lord, the subject matter in the suit, it is Suprakandi, and my Moza that has been done is Moza Lokhor Khai, my lord.
The orders clearly reflected Moza Lakar Khai.
Lokhor Khai.
Lakar Khai. Order is for Lakar Khai, Lordship.
That is
not defined Moza.
Lokhor Khai is not the subject matter of the suit. That is my contention, my lord. That is my submission. Schedule is there, my lord. My lord, may kindly come to schedule at page number 32 of the plaint, my lord. Schedule 1 land.
Page number
32. Pargona, Kusirkul, Moza, Suprakandi, Khotian number so and so, Patta number 180, subject dark number 508, new dark number 498. So this is the land, my lord. Whereas Moza is Suprakandi, my lord. Whereas my lord, the land that has been stayed for compensation amount, that is completely different Moza, my lord. In the counterclaim also, my lord, this is the same plot of land that they are also claiming. So if any decree is passed, the decree will be passed on these plots of land, not on the plot of land that has been stayed, my lord, for the time being. So defendants are not going to be prejudiced by any manner, my lord. Counterclaim schedule is also at my lord page number 54. That is also Moza Suprakandi. Whereas my Moza is completely different. Lokhor Khai. Tag number is also different, patta number is also different. And without being made a party, my lord, an order has been passed. Now, when I went to the deputy collector to collect the compensation amount, that amount has been stayed now. And one more submission is that, my lord, the suit was filed for declaration of right title interest. The compensation amount or anything of that sort, that was never agitated before the learned court below. That was never the part of the pleading also. There's absolutely no whisper anywhere in the plaint as well as in the written statement come counterclaim that compensation of the land was acquired by the government.
Mr. Gogoi,
Lords.
you go through the impugned order and also the order of awarding compensation. Where is that order? Page number?
Lordship, page number 75.
70.
75. And you go through the page number 75. No. The order of the deputy commissioner.
Order.
Order of the
That order.
deputy.
Is it available with you?
No, my lord.
We have to see in respect of which plot of land the compensation was awarded.
My possession certificate is there, my lord, at page 88. Page 88.
This is the possession certificate, Lordship. This is not.
Here, my lord, the land acquired for Bharat Mala project that is given. Description of the land that was acquired, my lord. At page 88, description of the land, name of Moja Lokhor Khai. Name of Porgana Kushirkul, Sara, plots of land, my lord, here in the first paragraph only it is written.
Here is Lordship village superkandi. In
So
case
Moja
number
is
88,
Lokhor Khai, my lord.
village is.
No, yeah. You first show us the order by which the compensation was awarded by the deputy commissioner.
These are not annexed here.
This is not.
Is it available with you? No.
Right now, it's not available.
Can you produce it tomorrow?
And let it come after vacation. Tomorrow it won't be possible.
Because we have to check the schedule of the land in respect of which this compensation amount was awarded.
Was awarded, Lordship.
Then I'll produce the notice, my lord. The whole copy that I get.
Then we will issue notice today.
My lord.
Third, Mr. Equal learning country for the petitioner and Mr. Gogoi to respondent number
Respondent number 6 and 7. Lordship.
6 and 7 and
7 and 8, Lordship. 6 revenue.
Tiva. Respondent number 6.
And 7 and 8, Lordship.
Respondent number 6, Mr. Gogoi for 7 and 8.
Lord.
In this petition under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, the petitioner has challenged the order dated 28/2/2025 and 29/4/2025 passed by the learned civil judge junior division number 3, Sirvami, entitled to number 105 of 2017. Here is the petition and the documents plus and report, and also here is the impugned order dated 28/2/2025 and 29/4/2025. Issue notice to the respondent, returnable in 4 weeks, that be taken by registered post with AD and also by legal process. Returnable in 2 weeks.
Immediately
That
after.
be taken by registered post with AD and also by legal process within a week. Okay. Additionally, dusty service is also permitted. After effecting service by dusty note, the counsel for the petitioner shall file an affidavit before this court on next day. This is the matter on 16/7.
16/7.
No, 16/7.
Applies.
Okay. For hearing, item 27.
My lord, it is an appeal filed by the claimant against the order award passed by the Motor Accident Claims Tribunal, wherein, my lord, amount claimed was 4,000 and the award was only 5,000, my lord.
Amount claim was
4 lakhs, my lord,
Ah.
and award which was awarded was 5,000.
5,000.
Yes, my lord.
Why?
My lord, what happened, my lord, in between, there was no representation from the council. The order sheet has been annexed, my lord. And from page 24, my lord. If your lordship comes to page 25, on 9, there is a type copy. Lordship has got it, Mel. Page 25, 9 to
Yes.
2. Claimant has submitted evidence of 3 PWs through affidavit, sin petition filed by OPs, paid where is allowed, fixed 10, 8, 11 for cross-examination. Petition of claimant for time is allowed. All the part from that day, my lord, from the next day, there was no representation. Although petitioner, the claimant submitted 3 PWs, they could not be cross-examined. my lord.
Whether you have annexed all those orders here?
Yes, but these are the orders, my lord. The original lordship, this is the type copy, lordship, annexure 4A, page 26 is are the orders, my lord, of the. And the judgment is at page 29. Is the type copy, my lord, and page 32 is the original.
Mr. Rosit?
Excuse me, Lord. In MACT court, my lord, it was started. They filed a claim petition and we filed list, my lord. That was filed on 21/4/2010. Then, my lord, data list of dates, my lord, actually given me an except 4, my lord, page 24, your lordship, may kindly see. Have you also got it? Below, my lord, 22/9/10, claimant is represented, no steps by the parties. Fixed so similar for document and issues. Later on, claimant is represented. Issues are framed above, date is fixed. And next, my lord, the case was fixed on, my lord, 9/2/2011. The case was fixed for, my lord, cross-examination. And on, my lord, 10/8/2011, petition of claimant for time is allowed. That means they took time, my lord, and there was no cross. On that day was fixed for cross. Then another date was fixed for cross, that is, my lord, 14/12/2011. And that date also, my lord, all parties are absent without any steps. So, my lord, cross was not done. And next date, my lord, that was 19/5/2012, my lord, claimant absent without any steps. And last, my lord, it was, my lord, 1st of August 2012, my lord, and the learned court, my lord, below, member MACT, my lord, he allowed the petition, my lord, and granted, my lord, only 5,000 rupees. As because, my lord, there is no any other document, nothing was there, my lord, just, my lord.
They have filed their evidence on affidavit.
But there is no cross-examination. They have not come, we have not come, nothing.
No, is it the manner to deal with an application claiming compensation?
And
under
moreover, my lord,
section
award
166?
has given me 5,000.
Hmm?
5,000. And appeal has been filed under section 173 of the MB Act. And under section
Claim petition was filed under which section?
166, my lord.
166.
Yes.
the appeal was filed here, before lordship. 173.
We are setting aside the appeal. No, sorry, this impugn judgment and award. And we will remand the matter to the tribunal.
But one thing here, the under section 173, subsection 2. Here is mentioned one thing. No appeal shall lie against any award of a claims tribunal if amount in dispute is in the appeal is less than rupees 10,000. But here is given 5,000.
Not on that ground. We will set aside this appeal. No, sorry, this judgment on the ground that no opportunity was afforded to the claimant.
No, claimant actually,
Passing the
claimant was absent. He was
judgment
given
and award.
Yes, my on 2 dates, it was absent, my lord. It was the fault, my lord, because due to wrong entry in the
9/2/2011 he was absent. And again, 10/8/2011 he was absent.
Third, Mr.
T Chakraborty, my lord.
D. Chakraborty.
T Chakraborty.
P.
T.
T. Chakraborty, learned counsel for the appellant, and Mr. Rosit for the respondent. In this appeal, under section 173 of the MB Act, the appellant herein has challenged the impugned judgment and award dated 1/8/2012 passed by the learned member, Motor Accident Claim Tribunal.
But once we your lordship may only on
Advantage.
this, sorry, my lord, once your lordship may can read this section, then your lordship may pass. 10,000 only limitation, and then below that, you know, they
On
can
that
file.
ground, we are not going to set aside it. We are going to set aside it without affording any opportunity of being heard. This appeal order was passed, impugned order was. On that ground, we will set it aside.
And even they have not annexed any Form 54, which is most urgent necessary.
That is the subject matter of the
Tribunal.
appellate, oh no, sorry, tribunal,
Fine.
not of this court. In MSC case number 2108 of 2009. It is to be noted here that by the impugned judgment and award dated so and so, the learned tribunal has awarded a sum of rupees 5,000 with interest at the rate of 6% per annum from the date of filing of the claim petition, that is 27/10/2009, till payment. Till payment. The background facts leading to filing of this appeal is briefly stated as under. The claimant, Sri Gopal Sando Dekka, has filed a claim petition before the learned member, Motor Accident Claim Tribunal, claiming compensation for the injuries sustained by him in a motor accident that took place on 17/7/2009, involving vehicle number WP-72-P-2632 within the track, which was owned by Sri Somerjit Singh. The respondent herein. The case of the claimant was that on the fateful day, he was walking from Tiniali Market towards his residence. Then suddenly a bike bearing registration number WB-25 struck B-2632. It was a bike or truck?
Two-wheeler, my lord. Two-wheeler motorcycle.
But it has been mentioned as truck.
Wrongly mentioned, my lord. It's a two-wheeler.
Bike. Which was driven in rash and negligent manner, knocked down him. As a result, he sustained grievous injuries. The respondent number 1 and 2 jointly filed a written statement denying the statement and averment made in the claim petition and stated that the accident took place due to negligence on the part of the claimant. And he has to prove the rash and negligence by documentary evidence. Upon the aforementioned pleading, the learned tribunal has framed following two issues. Number one, whether the claimant, Sri Gopal Chandra Dekka, sustained injuries in the alleged road accident dated 17/7/2009, involving vehicle number WB 72 stroke P dash 2632, then whether the said accident took place due to rash and negligent driving of the offending vehicle. Number two, whether the claimant is entitled to receive any compensation, and if so, to what extent and by whom amongst the opposite parties, comma, the compensation amount will be paid. Thereafter, the claimant has examined himself as PW1 and two other witnesses, and the opposite parties have not examined any witnesses. And thereafter, hearing arguments of both the parties, the learned tribunal, by reviewing judgment and award, has directed the opposite party, respondent, stroke opposite parties, that is the owner of the vehicle, offending vehicle, to pay a sum of rupees 5,000 with interest at the rate of 6% per annum from the date of filing of the claim petition, that is 27/10/2009.
Amount has been deposited, my lord. We have paid it. We have paid the same, my lord.
The learned counsel for the appellant has drawn attention of this court to the orders passed by the learned tribunal with effect from 27/10/2009 till disposal of the claim petition on 1/8/2012, and submits that on the date of passing the order, that is no, passing the judgment and order award dated 1/8/2012, and on 19/5/2012, the claimant remain absent, and though the claimant has filed, claimant has submitted the evidence of 3 witnesses through affidavit, yet the claimant and his witnesses were not cross-examined, and the respondent opposite parties have not adduced any evidence, though it has been mentioned in the impugned judgment and award that the claimant has examined himself as PW1 and two other witnesses, and contesting opposite party has not examined any witnesses, and that the tribunal has heard arguments of both the parties, as on the date of hearing, that is on 19/5/2012, the claimant remain absent. And there is no indication in the said order that the arguments of both the parties were heard. Then under such circumstances, the learned counsel for the appellant submits that the impugned judgment and award is perverse, and on such count, the same were an interference of this court. On the other hand, Mr. Rosid, learned counsel for the respondent, opposite party, submits that the tribunal has awarded a sum of rupees 5,000 being the compensation, and the same has already been paid. And referring to subsection 2 to section 173 of the ME Act, Mr. Rosid submits that no appeal shall lie against any award of a claim tribunal if the amount in dispute in the appeal is less than 1 lakh rupees.
Well, at that time, it was, at that relevant point of time, it was 10,000, my lord. Subsequently, in
10,000.
2019, it has been amended. Lordship can go to the earlier prior amendment act, my lord.
10,000, and
yes.
subsequently the same has been enhanced to rupees 1 lakh. In the amendment act, 32 of 2019. 32. Then under such circumstances, Mr. Rosid submits that this appeal is not maintainable, and therefore contended to dismiss the same. Having heard the submission of learned counsel for both the parties, I have calculated onto the petition, memo of appeal and the grounds mentioned therein, and also the impugned judgment and award dated 1/8/2012. It appears that in the impugned judgment, the learned tribunal has observed that the claimant has examined himself as PW1 and 2 other witnesses, and contesting opposite party has not examined any witness. But his finding, no, and it also appears that the learned tribunal has heard arguments of the parties, but the orders dated 19/5/2012 and 8/1/8/2012, and all previous orders dated 27/10/2009, 21/4/2010, 22/9/2010, 9/2/2011, 10/8/2011, and 14/12/2011 are contrary to the observation made by the learned tribunal in the impugned judgment and award. From the order dated 9/2/2011, it appears that the claimant has submitted evidence of 3 PWs through affidavit, and thereafter the learned tribunal has fixed the case on 10/8/2011 for cross-examination of PW. But on that day, that is 10/8/2011, the claimant has filed a petition seeking time. And thereafter, the learned tribunal has fixed the matter on 14/12/2011 for cross-examination of PW. Thereafter, on 14/12/2011, all the parties remain absent without any step. And the learned tribunal has fixed the matter on 19/5/2012 for cross-examination of PW and DW if any. On 19/5/2012, claimant absent without any step. And opposite parties present and PW absent. Evidence closed and fixed the matter on 1/8/2012 for judgment, and thereafter on 1/8/2012, the learned tribunal has pronounced the judgment as indicated herein above. Indicated herein above. It appears that the claimant has failed to produce the witnesses before the learned tribunal for cross-examination. And when the witnesses were not made available for cross-examination on that fix, the learned tribunal ought to have expunged the same. But without doing so, the learned tribunal has placed reliance upon the same and pronounced the impugned judgment and award. Further, it appears that the learned tribunal has not afforded opportunity of being heard to the claimant before pronouncement of the judgment. Under the above mentioned facts and circumstances, this court is of the view that the impugned judgment and award is unsustainable and contrary to the provision of law, and accordingly the same stands set aside and passed. The matter stands remanded to the learned tribunal to proceed with the same in accordance with law. Both the parties are directed to appear before the learned tribunal within on or before 2 weeks.
By
After 6 at that.
by 30th of next month, they will produce. Or the claimant will produce, then court may issue notice to the.
Both the party will remain present there.
30th of July. 30th of July.
30th July.
30.
Both the parties are directed to appear before the learned tribunal on that day.
I'm obliged.
Item 50.
Send down the record of the learned tribunal with a copy of this judgment and order.
My lord, please. My lord. Present applicant, who is the respondent in the rate petition, in the civil division petition? My lord. Here, my lord, I have filed this IA. Raising the question of the maintainability of that revision on the ground that the impugned order is in fact the judgment on admission. Lordship, that order was passed on my application, wherein I have stated that judgment. I prayed for passing the judgment on admission. That application in connection with that application, that impugned order, that your lordship will see page number 119. Page number 119 is that order which they have challenged, the opposite party has challenged. in the civil revision petition. So we said that no appeal lies, not the revision. When there is a appeal provision, so they ought to have filed the appeal instead of filing the revision. A very short question, my lord. Lordship will say that all. So which they have challenged. That order reminder 119, page number 119. That Lordship will see added. May I read?
Yes.
That the order passed on 15/12/2022. Party are represented. Learned counsel for the opposite defendant has filed a written objection. Heard both the side on petition number 2271/21 under the order 12 rule 6 CPC filed by the petitioner plaintiff praying for judgment and decree on admission. Also peruse the written objection filed against the petition. The plaintiff have filed the main suit for declaration, confirmation of possession and partition and permanent injunction. A meaningful reading of the pleading of the party disclose it is an admitted position that the late Shashi Kolita, Kashi Kolita was the owner of the suit property and the party to the suit are admittedly the legal heir of the deceased owner. It is also not in a dispute that the suit property is yet to be divided among the parties. Further, defendant number 1 has also admitted that she had been collecting the rent from the tenant of the suit land. During the hearing, learned counsel for the opposite party submitted that the opposite party has no objection against the relief claimed by the petitioner for partition of the suit property. Inasmuch as the relationship between the parties and the nature of the suit property are not in dispute, learned counsel for the petitioner submitted that if the opposite party agree to partition the suit property and the party
Mr. Upadhyay.
My lord.
So on the petition under
Order
Rule 12,
Rule 6.
the
Yeah.
Order 12, Rule 6,
Yes.
the court has passed the order,
Order.
judgment,
It amounts to the
passed the
judgment on
judgment.
admission.
and passed the decree.
Yes, not the judgment.
Judgment on admission and passed the decree.
Decree. Yes.
So against the decree, according to you, appeal is maintained.
Appeal lies.
Yes, how revision will lie, so it.
My lord, Lakshmi peruse my imputed order is my lord 117 page and two, my lord, there are two petitions.
There are?
My lord, is two orders, my lord, in 15/12/22, another two orders.
Page number?
Page number 117, my lord, 70.
No, in the IA.
My lord, main in my revision, my lord.
117.
My lord.
Yes.
And then in TS number, my lord, 27/22. In view of the order passed by today in mid-J case number 852, the instead suit is posted for hearing, judgment and admission on so and so date. So I, my lord, challenge the order, my lord, that in title suit number so and so along with the mid-J case number. So my case is that, my lord. My lord, the case will be clear from the result of order, my lord, passed by this honorable court, my lord, in CRP number 5.
So,
Page
you
number-
see, in the civil revision petition, the impugned order is dated 15/12/2022, right?
Yes, my lord.
And this order was passed under Order 12, Rule 6 of the CPC.
CPC, my lord.
And the Lorded trial court has passed the judgment and decree on admission. So whether civil revision petition will lie?
My lord. No, here, my lord, it is a judgment.
My lord, revision will lie, my lord.
How?
My lord, when, if we relied upon the, my lord, judgment on admission, my lord, if judgment on admission, my lord, then there is no scope to file appeal, my lord. If the judgment on admission, how can we file appeal, my lord? They have claimed something and I admitted and judgment was passed. And how will file, my lord, agree by that judgment, my lord? So revision will lie. That provision is clear by lordship.
Which provision?
Report SC. Good. Life or up now, life or you. 11.
Para 11, my lord.
Para 11.
My lord.
Read it.
It is true that, para 11, my lord, it is true that a judgment can be given on an admission contained in the minutes of a meeting, but the admission should be categorical. It should be a concise and deliberate act of the party making it, showing an intention to be bound by it, Order 12, Rule 6 being an enabling provision. It is neither mandatory nor preemptory but discretionary. The court, on examination of the facts and circumstances, has to exercise its judicial discretion, keeping in mind that a judgment on admission is a judgment without trial, which permanently denies any remedy to the defendant by way of an appeal on merits. Therefore, unless the admission is clear, unambiguous, and unconditional, the discretion of the court should not be exercised to deny the value right of the defendant to contest the claim.
So is there any indication that appeal or revision will lie in this paragraph?
My lord, here this line is which permanently denies any method in 11, last line, my lord. Which permanently denies any remedy to defendant by way of an appeal. Meaning thereby we could not file an appeal. My lord, here the last paragraph 11 of last 3 line, my lord. Here is written, admission is a judgment without trial which permanently denies any remedy to the defendant by way of an appeal.
No,
On
no,
merit.
no. This doesn't mean that you cannot file appeal. It means that you may file appeal.
My lord, when implementing, my lord, when they have claimed anything and I admit it, thereafter how can I agree, my lord, that?
Yes, Mr. Upadhyay, what judgment do you
My
have referred to? Which judgment?
My lord, is it- My lord, here, my lord, well,
You have referred to one decision of
I have no,
which decision?
My lord,
no, decision.
Supreme Court, my lord.
No,
No, I have not brought any decision.
you have not brought it.
But it's very clear, my lord, the section itself, 12.6, out of 12.6. So I read that section, 12.6, judgment on admission. On where the admission of the fact had been made either in the pleading or otherwise, whether orally or in writing, the court may any stage of the suit, either on the application of the party or of its one motion, without waiting for the determination of any other question between the party, make such order and give such judgment as it may think fit, having regard to such admission. Whenever a judgment is pronounced under sub rule 1, a decree shall be drawn up in accordance with the judgment, and the decree shall bear the date on which the judgment was pronounced. And it decree shall be done, my lord. When decree
And decree is always appealable.
applicable.
My lord, where the impugn order is, my lord, judgment yet to be passed, that is not.
No, that is,
Here,
it was,
no judgment was passed, my lord. From the impugn order, only the case is fixed for judgment, my lord.
oh no,
Here, the impugn order, my lord, 117. In view the order passed today, so and so, is for hearing judgment on admission on so and so. Hearing public judgment on admission on so date. On 4/1/23 for judgment, hearing and judgment. But it is not a clear judgment, my lord, it is order.
no. The order itself amount to judgment, no? No. Only because of that, this order passed in the title suit, The order pass in which case will not go, na? It will, the order will go.
Every order pass under order, my lord, 12 rule 6, my lord, is not judgment. When it is final, then it is judgment. my
The
lord.
nature of the, your lordship will say nature of the order. Accordingly, the petitioner prayer for judgment admission is allowed in terms of the order. My petition was allowed. Your lordship will say that petition. I have prayed. My petition is 97, page number 97. The prayer was allowed. '97, your lordship. Page number 97. They had also filed the objection. Their objection is 105. But my petition was allowed. So what remained?
This petition has been allowed by this order.
Why allowed? My petition was allowed. Now, there is a clear admission also. If we go through the pleadings, the written statement, it is admitted. Because your lordship's case is that the plaintiff, as many as 5 plaintiffs, they are the daughters. And there was a one son of Gauri Kalita. Gauri Kalita died, she was the absolute owner of the property, one or bed. Property devolved on them. That is why defendant admitted that, yes, each of the shareholders are entitled to the 1/6 share. And there is a clear admission in the pleading itself. Moreover, the
My lord, only
defendant
admission of only one word, one sentence is not sufficient by the whole title suit, my lord. It does not mean I are admitted in whole written statement, my lord. There are sufficient judgment regarding that the admission should be taken in whole of the written statement, my lord. Only here, only admission is that the defendants are my sister and they also entitled to get share. That is the admission in my WS, my lord. Only that word.
No,
They are also entitled to take share.
You go through the WS. Otherwise, court would not have passed the judgment on admission without categorical admission.
And the case will be clear if done through the earlier order, my lord. Page 89. Why this revision petition, my lord? There is a clear direction of this honorable court to consider my petition. Accordingly, court was fixed the case to consider my petition, but the trial court, without my lord, the order of this honorable court, my lord,
You see, my young friend, you see this admission. Yeah,
only one line.
not online. You see, there are entire para admitted.
And the system is petition is not also if the judgment is.
Huh? No, like no.
We given.
Page 1939. This one, you see. Yeah. The statement made in para 9 of the plaint are being matter of error are admitted by the answering defendant.
You see section 96.
Yes, my lord, section 96(3). No appeal shall lie from a decree passed by the court with the consent of the parties.
No, you have nowhere stated that we have given the
No,
consent. Their
that is
case is, my
that
lord.
is
their
not
ca-
a consent, consent decree. That
Their
was
case
not a
is
consent
that
decree.
they have not pleaded in their revision petition, they have given the consent. Their case is, we have no admission, we have not given any admission, consent, we have no admission at all. In that case, it lies.
An order was
Appeal lie.
passed
That
on
they have,
petition, meaning
they
that
have
with that
challenged that
consent.
admission. They have challenged their own admission, that we have no admission. In that way, they can file the
Okay, let us do one thing. We adjourn the matter today.
Yes.
Yes.
We will hear it after reopening. You come prepared?
Yes.
But who referred this judgment? Mohammad Mohiuddin AM versus Mohesh Kumar Asova of Andhra Pradesh High Court.
We shall.
And in this judgment, it is observed that this appealable by virtue of section 96 CPC. Anyway, we will see.
Well, that is High Court's order, madam, but most probably that is not High Court's order, madam.
Yes,
High Court order, but I place because Supreme Court order.
maybe.
Earlier, my lord, learned friend filed this order.
Third, Mr. Upadhyay, learned counsel for the applicant, then Mr.
M. Hussain.
M. Hussain, learned counsel for the respondent. Third in part, list the matter.
Opposite party petitioner, by. Opposite party petitioner.
I am passing the order in I.
Am I?
Yes. Date. After reopening. 17 July.
17.
As parted.
Yes.
Next matter.
Obliged.
Timing item 16.
This matter appeal was admitted and this II is for stay. The matter is listed for consideration of the stay.
When the appeal was admitted.
Appeal was admitted, Lordship.
When?
That's about 5-6 months back, Lordship. I don't have the date exactly. Let's take up the stay petition.
Bill was admitted, my lord, by the order dated 7/11/24, my lord.
7/11.
My lord.
So their service completed in the appeal. LCR has been received.
LCR. Service only one respondent.
In the meantime, the execution proceeding started.
Started, Lordship.
Where is the order?
Even before the admission of the appeal.
Where is the order?
That order I have not annexed, Lord.
Not the next. That is what it says, that proceeding is pending.
Yes, Lord, I have stated.
My lord, this,
I have
no, this
stated
is money
this is
degree.
pending.
Proceeding for realization of money is there, my lord.
Proceeding for?
Realization of digital money.
This is paragraph 9, page 12 of the stay petition.
It is execution.
Family already filed execution petition by the execution case number 44/22 and has by filing a petition number so and so prayed for stopping operation of bank account of the judgment debtor. It is a paragraph 12. Now, Lordship, money decree, as there is provision in the CPC that some amount to be paid. And I want to raise before your Lordship that the decree itself is illegal. Therefore, my prayer is that at this stage, the entire decree may be stayed. And I will show your Lordship
entire decree may be stayed. My lordship may see the agreement.
Oh, what is the decretal amount?
It was a big amount, Lordship, 1 crore. 19 lakh 5,500 Lordship.
Hmm.
With 6% interest on that.
No, you deposit some of the amount.
Lordship,
Security.
that is what I want to submit you before Lordship. Lordship, the petitioner is a government. That is number
No,
one.
no, the different heuristic cannot be applied.
That is one thing. Secondly, Lordship may kindly see whether the degree is proper. Because it is followed by an agreement. There was a both the party entered into an agreement.
No,
Agreement is
no,
a pay
we'll not hear the matter on merit now.
Lordship, otherwise I don't have to pay a single pie to them. If your lordship satisfy, I can satisfy your lordship.
No, we are not
Because-
hearing the appeal on merit.
Only
Unless
your-
you deposit 50% of
Only,
the
only
amount.
because as per the
Decretal
agreement,
amount will
as
not
per the
pay.
agreement, there was
Sorry,
no justification that I should pay them the amount.
sorry. We are not hearing the appeal on merit.
Lordship,
We are
I
on
had
stay petition, and unless you deposit 50% of the decretal amount, we will not stay.
The lordship can see page number 93 of memo of appeal, my lord.
Page number?
93 of memo of appeal, my lord. They are saying degree is nullity, degree is illegal. Lordship, what is on record, my lord?
Yes, page number 93.
93 by internal page number 10, my lord, paragraph 6.
Internal page number?
10, my lord, at the top.
Yes.
Paragraph 6, my lord. Plaintiff side during hearing examined two numbers of witnesses, SPW1 Sri Deva Borkar Takuri and PW2 Sri Deepak Kumar Pudar. Both the PW1 and 2 have submitted their evidence in chief through affidavit reproducing the contents of the plaint. But the defendant's side had failed to cross-examine both the witnesses. Par contra, defendant's side failed to adduce any form of evidence before this court. Well, where is the illegality caused by the trial court, my lord?
Lordship may see page 20 of my stay petition, Lordship. For 5 minutes, I will complete. In 5 minutes. Page 20. IA.
Page number?
20.
Yes.
The agreement is dated 25 May 2018, it is at page 18. I directly come to page 20. Clause 1. Now, therefore, this agreement, that clause 1, that the second party will have to pay the entire lease value in 3 installments. That is 40% as first installment, 30% as second installment, and the balance 30% on or before 4 months of the year end. This must be complied. What happened, you also will find in the appeal memo plaint. There are 9. There are 10 lots. I started from para 9. That in me mentioned in the clause 3 of the deed of agreement dated 25/5/2018. And the letter dated 24/5/2018 as well as endorsement dated 24/5/2018 made on the body of the same clearly empowers and provided sanction to the plaintiff to innovate in the development of the infrastructure for smooth management and maintenance and operation of duly handed over list of rubber gardens by the plaintiff. Accordingly, in the developing the infrastructure as well as plantation providing water, electricity, repairing of motor vehicle machinery, ASV bills, repairing of smokehouse, as well as other plantation activities, garden accessories, office premises, and
You were reading paragraph number 9
9, Lordship.
of your application. IA.
No, of the appeal.
Appeal.
Yes.
Page number?
Page number 32. Para 9 starts from page 32. It may be mentioned.
Yes.
That it may be mentioned here that the clause 3 of the deed of agreement dated 25/5/2018 and the letter dated so and so as well as endorsement dated so and so made on the body of the same clearly empowers and provides sanction to the plaintiff. Also, I skip this part. Now, what happens? They paid some amount. It is about 68 lakhs. See, page 31, it is in bold letter in the middle. It is said that letter 42, the defendant number 2 has clearly admitted receipt of total amount of rupees 64. It is at page 31, Lordship. 64 lakhs 80,600 out of 80 lakhs. From the plaintiff till 4.
Paragraph number?
Paragraph number 7. It is at the middle. First, that law portion, rupees 80 lakhs, that is the total consideration amount. That is to be paid by this as per the agreement. 70% before and 30% 4 months prior to the date of agreement. Date of year end. Now this 64,800 rupees was 64 lakhs 80,000 rupees was received by the defendant. It is admitted herein. Now, as per the agreement, they should complete the payment of that 80 lakhs. 4 months of the year end. That 4 months of the year end from 28/5/2018 comes to 31st January 2019. They have not made that payment. It is their less on their part, and therefore the on 1/2/2019 it is at page 10. To the utter shock and surprise, the plaintiff had unilateral letter dated 1/12/2019.
Anyway, we are not hearing the matter on merit. If you want this court,
because they have not complied.
Let us fix it that we will hear you on merit.
Yes, Lord.
But there shall not be any stay.
Lord, may hear the matter. Yes.
Okay.
Final work order is that fixed on 26 July. So maybe prior to that, fix the matter.
Yes, fix it.
23rd July. Not
23rd July. Third, Mr. Sharma, learned counsel for appellant, Mr. Alam, learned counsel for the respondent, as agreed by learned advocates of both the parties, SSL is the matter for final consideration on 23/7/23, along with I number 244/2024. Your good name? P. Hazarika. For respondent number? 5, 6, and 7.
Maybe on 17th or 17th July.
No, not possible.
On 18th. 23rd of July.
Hearing it.
24th
July?
24th. 23 that date is 22nd.
22nd.
22nd. Obliged.
Much.
Timing item 33.
Lordship, here in this case, the petitioners have been arrayed in a divorce proceeding as party, as the defendants. So if the petitioners have filed an application for deleting their names, because otherwise in a divorce proceeding, when the wife has filed the application for granting divorce, there is no reason for arraying the father, mother, and other relations as party to the proceeding. So we filed an application, Lordship, which is at page number 16, annexure 1, Lordship.
Page number?
16, Lordship, annexure 1. A petition under Order 1, Rule 10 of the CPC. So the petitioner filed the instant suit under section 12(1)(a).
Where is the impugned order?
Lordship, impugned order is at page number 30, Lordship.
Page number 30.
Yes, we start from page number 25. Lordship.
So on what ground your petition was dismissed?
Yes, Lordship, this is the operative portion is at page number 31, the last paragraph.
Yes.
Paragraph number 15. Furthermore, this court as a civil court is obligated to hear from all parties against whom allegations are made in the pleadings. In the present case, the petitioner has articulated specific allegation against respondent number 2 to 12. If the court were to dismiss their names at this stage, it could lead to prejudice in any determination made upon the conclusion of the original suit. In the light of the aforesaid consideration, this court is compelled to conclude that respondent number 2 to 12 have been duly and properly named as parties to the suit, and their presence is essential. Essential. Accordingly, the request presented by the respondent number 2 to 12 lack merit both in terms of legal standing and factual basis. Lordship. Now, the application for divorce was filed with a prayer for dissolution of the marriage between the petitioner and the respondent by decree of divorce, and the second prayer for taking return of the Sridhan. So this is the main prayer in the main divorce petition. Lordship. There is no connection whatsoever. In our petition under order on Rule 10, we have made a specific statement. If your Lordship kindly take a look at page number 17. Page number 17, paragraph number 2. We have mentioned about the relations that the respondent number 2 is the father, respondent number 3 is the mother, 4 and 6 are the sisters, 5 and 7 are brothers-in-law, 8 is the paternal uncle, 9 is the first cousin brother, 10 is the cousin sister, 11 is the maternal uncle.
So where is the plain?
Plaint I have not annexed, Lordship. At that point of time, I have a copy. I have obtained a copy, Lordship. Lordship can take a note of the prayer.
When the next date is fixed?
Next date is on 30th, Lordship. 30th of this month, Lordship.
To file an application there.
Lordship, that was filed, Lordship, that has not been accepted.
You bring the same, bring the client on record by filing an additional affidavit.
Lordship, this is only with regard to dissolution of the marriage. Lordship can take.
Maybe, but some other allegations are also there.
There is no allegation, Lordship. I can place it in the form of additional affidavit, Lordship.
Yes.
But considering
next
the
date, we will consider it.
Lordship, considering the next date, Lordship, the stay is not granted.
File
Lordship.
an application there that one revision.
That has not been
petition is
considered,
pending.
Lordship. That has not been considered.
When
Because on
you
the
file
last
the
occasion,
application?
after filing of this petition, Lordship, before this honorable court, Lordship, I moved an application before the concerned court.
Heard Mr. S.P. Soduri, Learned Counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 13/5/2025, passed by the Learned Additional District Judge Tinsukia, whereby the Learned Additional District Judge Tinsukia has dismissed the petition filed under order
One Rule 10.
Rule 10 within the 2. With section 151 of the Code of Civil Procedure. Having gone through the record, I find that the plaint of the PS within bracket M case number 204 of 2024 is not enclosed with this civil revision petition.
Lordship can fix on 30th of Lordship. I will file it back tomorrow, Lordship. 30th of June. Vacation code is there on 30th.
Vacation court only urgent matters are taken.
Lordship, this is also urgency, Lordship. This matter will proceed, Lordship, and thereafter I will not be allowed to file my written statement also. The court is not inclined to pass any order setting aside this one.
Accordingly, it is provided that Mr. Soduri, Learned Counsel for the petitioner shall bring on record the plaint of the title suit number
116 of 2024.
116 of
2024.
116 or 204 of 2024.
Yes, Lordship. 206, sorry, Lordship. 206.
204 of 2024. By way of an additional affidavit, place the matter before the vacation bench on 30th.
Always, Lordship.
Yes.
Item 35.
That's I was to place the judgment on parity, my lord. So, my lord, the first judgment I'm placing on parity is, my lord, 2023 12 SCR 220, my lord. Para 15 is relevant, my lord, in this. That will make sense. INSC. My lord, para 15. And on the second page, my lord, on the second page of this, my lord, judgment, my lord, that page 221, my lord, to find that the principle of parity has been explained in this case, my lord, by the Honorable Supreme Court, my lord, para 15, my lord, internal page, my lord, 231. Para 15. When there is a similar or identical evidence of eyewitness against two accused by ascribing them the same or similar role, the court cannot convict one accused and acquit the other. In such a case, the cases of both the accused will be governed by the principle of parity. This principle means that the criminal court should decide like cases alike, and in such cases, the court cannot make a distinction between two accused. Which will
Other day, I have put the question whether principle of parity will be applicable
Yes, my lord.
in bail application.
Yes, my lord. This is what, my lord, in the bail applications also, my lord, I'll place other judgment also. I have brought other judgments also, my lord. What I'm on is that, my lord, for a moment, only one submission, my lord. I'll take only 10 seconds, my lord. Page 32 of the charge sheet. Page 32 of the charge sheet. Page 32 of the charge sheet, my lord. Para 5. My lord, this particular line in the charge sheet, my lord, will cover my case, my lord. Page 32, my lord, para 5. That the Tata truck bearing registration number HR 55K 5550 was thoroughly searched and a special cavity was found behind the cabin of the truck, and it had double wall made of tin and plywood. So, my lord, the other two, the last person whose bail order I have annexed, my lord, which was of the coordinate bench of this honorable court, it was of the owner who was inside the truck. So, my lord, their allegation is that for 20,000, I am carrying the contrabands, my lord. This is their statement as per the charge sheet, my lord. But, my lord, if the owner is sitting and he is allowing me to create a wall and a cabin to hide that, my lord, can it be possible, my lord? A 40 lakhs truck, my lord, would be allowed by an handyman to make a secret cavity and conceal contrabands, my lord. So, my lord, I'm similarly standing with the accused, but the other accused person, because, my lord, I was inside the truck. The contrabands were found from all the three of us, my lord.
Mr. Tewari, you first show me the proposition that this principle of parity is applicable in bail applications.
Yes, my lord. This is what I'm trying to place. Because on the other day, my lord, I have just given a judgment of Suraj Vijay Agarwal versus the state of Maharashtra. 3-bench judge of the Honorable Supreme Court, my lord.
Yes.
My lord, in that judgment, the Honorable Supreme Court, my lord, at para 6, my lord, my lord, held that, however, in para 5, my lord, the petitioner is directed to be released on bail in connection with so-and-so, dated so-and-so, registered so-and-so, to the satisfaction of it. Para 4, my lord, the court says that, taking into consider the fact that this court has already granted bail to the other co-accused, we are inclined to bail to the petitioner.
Whether any law has been discussed here?
No, my lord, the law, my lord, that is why, my lord, the law which I tried to place from Javed Akhtar, my lord, which has been cited in other judgments also, my lord, the Supreme Court is of the view that in a case of parity, my lord, what lordship would differentiate in allowing a bail application is that the role and conduct of the accused in the commission of the crime, my lord. So, my lord, here my submission is that they could not differentiate me from the other two. Had they could have been able to differentiate, because the Deepak Yadav judgment.
Is there any allegation against the other two accused of receiving the sum for carrying the contraband substances in the vehicle?
That is also there, my lord. Against them also the very same allegations are there. Very same
About
allegation.
receiving money. About receiving money.
About receiving money, what I'm on is that, my lord, I am only a handyman, my lord. I am not the owner of the truck. That is an admitted position of there also, my lord. And now, my lord, their own CD and their own search warrant says that, search and seizure says that a secret cavity with tin shed and plywood was made in the truck. And, my lord, the owner is sitting. then my lord, can an owner allow me? My lord, would he will not find any changes in the tract?
We are now not considering the case of the owner.
No, that is what, my lord, I'm saying. Parity I'm claiming because of the fact only that, my lord, since I have been. Then the other judgments, my lord, or the judgment which my learned brother has shown, my lord, Deepak Yadav versus State of Uttar Pradesh, my lord, the three judgment, my lord. The relevant para was at page para 41, my lord. But there, my lord, the Supreme Court was of the view the grant of bail to respondent accused only on the basis of parity shows that the impugning order passed by the High Court suffers from the vice of non-application of mind rendering unsuitable. The High Court has not taken into consideration the criminal history of respondent number 2 accused. Nature of crime, material evidence available, involvement of the accused number 2 in the said kind and recovery of the weapon from his possession. So, my lord, here is the case that the concise position is from all the three, my lord. It is not just separately from my own position. My lord, it is only their statement that 20,000 I have received. But my lord, if the law of evidence is taken care of under section 24 and 25 of the Evidence Act, my lord.
Okay, all right.
My statement before the police officer is not admissible in law. Thereafter, my lord, I'll place the judgment of my lord Mohammed Muslim, my lord, wherein also Supreme Court says that in a case of bail, my lord, further 2 co-accused have been enlarged on bail, my lord, para 20 and 21, my lord. I'm placing this, my lord. Thereafter, my lord, I'm also placing a judgment of my lord 2021, my lord, in Union of India versus K. Najib, wherein the High Court granted bail, my lord. The Union of India went to the Supreme Court, my lord. Wherein the same aspect was taken that, my lord, here, my lord, the constitution validity and speedy trial, because he was also there for 5 years in jail, my lord. So the speedy trial was not granted. So for that, my lord, that bail is there.
Oh, how long you are behind the bar?
4 years, 6 months. 4 years, 6 days, my lord. 4 years, 6 days, my lord. Today, my lord, it will be 8 days, my lord, as on today. And the owner who granted bail was behind the bar for 3 years, 10 months, my lord.
Okay, okay.
Yes,
Mr. Kair.
I'm obliged, Your Lordship.
Please, my argument on last occasion, I submitted 3 judgment. On Palalu Ahmed, Lordship, 3 judge bench. It's clearly stated in paragraph 11 that parity cannot be a ground in bail application.
Paragraph number 11.
11. Last occasion, Lordship, considered this judgment.
Whether the principle of parity was considered in
Yes.
paragraph number 11?
Yes, Lordship.
Last
Last 6 lines of paragraph 11. We are of the firm view that accused A2 cannot seek parity with the other aforesaid co-accused, and no such benefit could have been extended to him in view of section 37 of the Act when he was found to be in conscious possession of commercial quantity of psychotic substance as contemplated under NDPS Act. This being the position the petitioner and NCB succeeded in so and so, so and so. On earlier occasion, Lordship has considered, I have given to judgment of your Lordship, also Lordship, that judgment has been considered by Lordship.
So, my lord, the concise position with all 3, my lord. And the other 2, my lord, remaining accused have already been granted bail, my lord. This is my humble submission. Nothing more.
In which paragraph this principle was considered in the decision of this court?
Lordship, paragraph 4.
Which judgment?
It is that State of Bangalore versus Pallalu Ahmed Amritullah. That I have cited today. In paragraph, Lordship has considered my submission in paragraph 5 and Lordship's observation in paragraph 6 to 9.
Heard Mr. Tiwari, learned counsel for the accused, and file learned standing counsel for the NCB. Argument concluded, order reserved. Much
Deeply obliged, Your Lordship.
admission. Production list, item number 1 for admission.
May I please, Your Lordship? This FAO has been filed against the order dated 14/5/2025. Logic will find the order at page number 98 in the appeal memo. This petition was filed under Order 9, Rule 13 for setting aside the ex parte judgment and decree. The first para, the white petition number 864 of 2022, filed by the petitioner defendant under Section 5 of the Limitation Act, praying for condonation of delay in filing petition under Order 9, Rule 13, read with Section 151 of CPC to set aside the impugned judgment and decree dated 4/3/2015, passed in money suit number 14 of 2014, is being disposed of. Lordship may kindly come to the relevant portion of the order at page number 104. 104. The third para, 104. The court has recorded that it is seen that the suit was decreed on 4/3/2015, while the instant petition was filed on 4/8/2022, along with a petition under Order 9, Rule 13, read with Section 151 of the CPC, that is.
Okay, this impugned order is dated 14/5/2025.
14/5/2025.
You are reading paragraph number?
Paragraph number, page number 104. Kindly come to page number 104. The facts have been narrated. I am taking your lordship to the finding of the court.
Yes.
Page 104, paragraph starts with it is seen that the suit was decreed on 4/3/2015, while the instant petition was filed on 4/8/2022, along with a petition under Order 9, Rule 13, read with Section 151 of the CPC, that is 7 years, 4 months after the ex parte decree. The reason cited for the delay is that the assistant government pleader, who generally took all steps in regard to this case, failed to appear in the case, and that he did not inform the defendant's petitioner about the case. It is stated that the absence is not deliberate and was occasioned because of want of knowledge, as they were not informed about the fact that the suit was fixed on that day by their counsel, and for non-appearance of their learned counsel on those dates fixed, which he failed to file petition under Order 9, Rule 13 CPC on time. In support of his claim, the petitioner, Executive Engineer PWD NH Division Nagaon, adduced his evidence at PW number 1. The same appears to be a repetition of the averments made in the petition. The narrative of the petitioner is simply that the engaged counsel did not appear and did not inform him about the decree. He learned about it only after receipt of the notice in the execution proceeding and was thereafter caught by surprise. This very explanation demonstrates utter carelessness on the part of the petitioner, because the litigating party ought to be more vigilant than that. The petitioner should have better explanations for the inordinate delay than merely stating that their delay was owing to lack of knowledge on their part, as the assistant government pleader did not inform them. And finally, now the law of limitation, the court has discussed. Finally, let me kindly come to page number 107. This is the final order. In the present case's hand, the petitioner is putting the entire blame on the assistant government pleader and trying to wash his hand off of his duty to have been vigilant or more proactive in the suit pending against them, as has been pointed out by the learned counsel for the opposite party plaintiff, that the accounts officer of the plaintiff's office had been summoned as an official witness and examined in the court on 22/12/2014 as a plaintiff witness after the suit had proceeded ex parte against them. Therefore, it seems unlikely that the petitioner officer had no knowledge about the suit having proceeded ex parte. But what has happened? One of the accounts officer was called by the plaintiff, the contractor, as PW number 2. He deposed against the department. The court below has considered that since the accounts officer came to the court and adduced his evidence as PW2, the department has knowledge. In my respectful submission, my lord, he went as a PW2, he was called by the contractor in connivance with him, and his personal knowledge may not be treated to be the knowledge of the department. Then, my lord, accordingly, he is held that further no sufficient cause has been shown for the delay and indeed they are unreasonable, allowing the application merely for the sake of hardship caused to the petitioner would appear to be mockery of justice, and accordingly, my lord, the petition has been rejected. But I'd like to take your lordship to the ex parte judgment and decree, my lord. I'll take to the ground. Before that, my lord, I'll take your lordship to page number 30, my lord. This is the
Let us do one thing. Let notice go at this instance. When
Lordship.
we
Lord-
state a proceeding further.
lordship, my lord. My lord, just one sentence, my lord. I'll take your lordship to page number 33, my lord. What is the decree? Kindly see, my lord. Page number 33, my lord, the last paragraph of the judgment in the ex parte judgment, my lord. Page number 33. The judgment and the ex parte judgment starts at page number 30. I'm taking your lordship to relevant paragraph, page number 33.
Yes.
The last paragraph, my lord. In the result, the suit is decreed ex parte with cost. It is declared that the plaintiff is entitled to recovery of rupees 29,41,990 only from the defendants with interest at 6% per month. Per month, my lord. That is what I would like to show, my lord. From the date of institution of the suit till realization. Then, my lord, the decree I have next, decree at page. But this amounts to interest 72% per annum. 6% per month, my lord. My lord, kindly come to the notice, the execution notice we received on in the month of June, last part of June 2022, and page number 37. This is the execution notice. But although the ex parte judgment judgment and decree was passed in the year 2015, the decree was put to execution in 2020, and the steps was taken in 2022. I have annexed all the order sheets of the execution petition, my lord. Page number 37.
They are to actually only.
Okay, all right.
My
All
lord.
right.
At this stage, that is my prayer, my lord.
They not learn it senior government for the appellant.
All the appellant, my lord.
All the appellants. This appeal under order 43, rule 1B of the Code of Civil Procedure is directed against the order dated 14/5/2025 passed by the learned Civil Judge Senior Division Noga. In Mizze case number 40 of 2022, in Manisut number 14 of 2014. It is to be noted here that by the impugn order dated so and so, the learned Civil Judge Senior Division Nagaon has dismissed the petition filed by the appellant Sherry for petition. No, for setting aside the judgment and decree, ex parte judgment and decree dated 4/3/2015. Passed in Manisut number 14 of 2014. There is a memo of appeal and the grounds mentioned therein. And also there is the impugn order dated 14/5/2025, passed in Mizje case number 40 of 2012, in Manisut number 14 of 2014, and also there is the ex parte judgment and decree dated 4/3/2015, in Manisut number 14 of 2014. Admit, issue notice to the respondent, returnable in 4 weeks, that be taken by registered post with KD and also by usual process within a week from today. List the matter after 4 weeks.
But
And in the interim, considering the submission of learned counsel for both the parties, no, counsel for the appellant, and also considering the facts and circumstances of the record, the impugn order dated 14/5/2025. Whether execution proceeding started?
Execution is there, my lord. I have annexed, and page number 76. Can you see the order? Execution order, my lord. I have prayed for stay of this order, 19/6/25.
76.
Page 76. 19/6/25.
Last line. you take down this way, pending further consideration, impugn the money execution proceeding. Being
Money execution one of
and
20.
money execution number 1 of 2020. Since state till returnable debt, list of reports.
I'm highly obliged now. Obliged.